Hello, hello, amazing law nerds. We are gathered here today to go to court in Idaho. Why? Because Judge hmm, set a second hearing with regard to the defense's surveys of potential jurors. We just finished our members only live stream. It will be back up for you later. I wanted to make sure everybody that was watching that contemporaneously wasn't like, wait, what's happening? We're going to court. We're going to court now. Pause, we'll be back. So we're going to roll the intro. We're going to do a very brief road so far as everybody comes in. And replay crew, as always, love you. Timestamps are down below. We're celebrating one of our law nerds, Bryn, who just got accepted to law school, which is very exciting. So you will see that in the chat as well. So with all of that, we need to roll the intro real quick. So let's roll. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. All right, let's do a quick road so far of what's going on in Idaho. With the Bryan Kohberger case, they were in court last week to talk about the surveys that came to the attention of the prosecution. The defense was sending out surveys and finished their surveying in Latah County, where this court sits, where these murders happened. The defense has a pending motion for change of venue. The defense was very clear in citing the case law that said to show or to get a change of venue, you have to show that there is more than just a lot of publicity, right? Just a lot of publicity is not going to do it. You have to show more. And so Ann Taylor has argued that to show more, you need to show that jurors or potential jurors in the jury pool have been impacted. Ann Taylor hired an expert to help determine how many people needed to be surveyed, to craft those surveys, and then hired a separate firm to go ahead and start cold calling potential jurors, so the population over 18 that could be on the jury rolls, and asking them general questions and then more specific questions. And the more specific questions came to the attention of the prosecution, and the prosecution went, "What are you asking?" And I've clipped those questions down on the Quick Bits channel. We've got a quick summary of those questions. The prosecution did not argue that the survey's not allowed, that these types of surveys can't be used, that any of the questions in the survey violated rules of court, local laws, case law, or anything like that. The entire argument was whether or not the specific questions on the survey violated the non-dissemination order in the case. That is the question. And I know a lot of us were sitting here going, those questions though. But the prosecution never argued that the questions are improper of anything other than the non-dissemination order. And that's what they are talking about today, and to try to see if any of the survey can be salvaged. So I think we will hear from the expert today, who had a very interesting resume that we went over when all these motions went down, in doing this kind of work in social psychology. And I'm interested to hear from the expert, not just from the lawyers arguing over it. Chat, yes, we did hit 750,000 subs. We will celebrate it after court or when court takes a break. How long will this hearing be? I don't know. Do I anticipate hearing testimony in this hearing? Yes, I do. I absolutely anticipate that we will hear testimony. So we are preserving this hearing on our end so that we have it, so that we can go directly into court. As they got started, this court puts these things up on their channel like as they are live. It is wild. So with all of that, I am going to get us rolling into court. I am going, Emily, is your screen shared? No. I think that was a decent road so far of where we are right now. I will be answering questions and saving questions. Lawnards, Lawnards, we will celebrate it's like 10 seconds. I hear you. You've spoken. We did bang. Oh, it banged. Move your head. Ah! And now, law nerds, we must go to court. All rise. Court is now in session. All right, we'll see how that plays. I think we might. We're gonna keep using our all rise. Let's make sure this is no. I don't need to get distracted by the Instagram shorts or the YouTube shorts or the shorty shorts. Hold on. I'm gonna bump this audio just a little bit on my end because court is recorded on a potato. Let's do that.
And the issues on the 6th and the issues that we have here today is first, whether there was violation of the non-dissemination order. And if so,
remember, this court puts this up on their YouTube channel as they are like in mid-sentence. So we are live in court. We are a few minutes behind. So if we need to zoom, we will. But we are live in court in Idaho.
Where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize that the defense would like to.
The prosecution just said, I think what the judge determined, Judge John Judge, was that the fact, wait, Emily, fingers, that the fact-specific questions violated the non-dissemination order. That's not exactly what the court said, I don't think. So we'll see.
And the issues that we have here today is first, whether there was violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realize.
I think Judge just said, yeah, which is not a ruling he put on the record. Sorry to keep pausing. When the prosecution said that the fact-specific question violated the non-dissemination order, Judge was like, yeah, which I'm interested to see what Ann Taylor has to say, because unless he ruled it after he adjourned court, there's no text ruling, there's no docket ruling, but the prosecution seems pretty confident that those questions were determined to violate the non-dissemination order. And everyone seems to be on the same page, except for us, who are like, well, when did that happen?
The defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because
yeah, please, we're confused.
11 this morning, we got what was up on the screen there.
There's nothing on the docket, sir. Nothing's on the docket.
A PowerPoint that apparently Mr. Edelman prepared.
The expert.
And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court.
It's not before the court
at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 11:15 when we got this today, and so we just figured we could raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here?
I thought so too. I didn't think that the court had already ruled. I thought so too. I thought so. I thought so too. So I'm not surprised that Ann Taylor's like, I didn't think we ruled. I didn't think the judge ruled either. But the prosecution's like, you ruled. And the judge is like, yeah. If I was Ann Taylor, I would be out of the gate pissed about that. I would be out of the gate pissed about that. That the prosecution and the judge are like, oh no, we're all on the same page. And she's like, what are you doing?
Survey. Dr. Edelman has made himself available in court to explain the survey, the process
in
of the
person.
survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon, and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
I also think it's fair for the defense to say, look, we need a little bit of a dive into what the defense has to prove for the change of venue motion, because that goes to why the survey is created the way that it's created, right? So for the defense to make sense of the survey, they also have to remind the court, hey, this is what we need to prove when we argue this motion. We're not asking you to hear the motion. We're arguing to hear why we need to do this because the motion is down the road. I understand that argument. Judge was mad last time they were in court last week and seems a little like, go ahead.
So
Actually, Your Honor, Ms. Taylor still has a copy of the PowerPoint that made available to the court.
okay, so seems like this happens to me in this case, that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like
Judge is a pretty easy read as a judge from my perspective. I don't think anyone would disagree with me on that. Judge wants to be inextricably involved in this case. He is immensely hands-on in a way that I think if I had to practice in front of him, though I am loving it from this perspective and this side of the computer, if I was having to practice in front of him, I think I would be frustrated and maybe a little like, yo, can you let us just do our case? But Judge is so wanting to be hands-on that this is where part of this power struggle is coming in court, because I think the prosecution is leaning into that a little bit, strategy on their part. And Ann Taylor's like, but you have to let me do my job, and my obligations to my client are different than anyone else's. And you can't tell me how to do my job if it's within the bounds of the law. So you can't micromanage me, because as a defense attorney, what I have to do is make sure that you and the prosecutor do your jobs, but you can't tell me how to do my job. So I need you to stop. And that's, I think, where we're feeling the tension, and where Judge is like, well, you all are like arguing over whether I should hear the case. Sir, yeah, that's like what they do. So I get where she's frustrated.
sometimes I'm making decisions that I'm in the blind here. So I'm gonna look this over.
Your job is to call balls and strikes. You set the hearing for today. You're not going into anything blind. Sir, I disagree. I disagree with all of how we're starting this.
Any problem with that, Ms.
Well,
Taylor?
Judge, give me just one
She's
second.
like, I do have a problem with that, actually. She's like, exactly. Yes, I do. I love that the expert's in court, not on Zoom. He was on Zoom last time.
Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today, and we're ready to go.
All right, Your Honor, just
When I said Ann Taylor was annoyed, I was not wrong that Ann Taylor is annoyed. I don't blame her in this circumstances. I don't blame her in this circumstance. They set this hearing to hear from her expert, and now the prosecution is like, well, if the judge already ruled that the questions aren't right, should we even be hearing from the expert? And she's like, that's why the fuck we're here, though. I'd be pissed if I was her too with this.
to clarify, as we made clear the last time we reported, we are not saying Ms. Taylor herself violated the non-dissemination order. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the surveyor takers. And they are loaded questions.
And I get why he's mad.
Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And Ann's going to argue that that's not the point. The point is not whether or not the questions of the survey are true. Ann Taylor's point is, how can you determine if a jury pool has been influenced in any way by the media reports without saying, did you hear this in the media report? Where the prosecution is like, why aren't you asking open-ended questions? Have you heard about this case? And that's why I think the expert is here to explain why you can or can't get the information they need with open-ended questions or not. So let the expert, isn't that why we're here?
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
I agree with her.
Number one, I'm past that. I'm not going to violate you. I mean, this was a communication.
We have violated
violated with.
No, the court says I'm not going to violate you, and I pull up a question to start talking, and then I'm like, wait a second, that went the wrong way. What's Alika? We did summon Robin Runkle. I love that we have summoned everyone. It is so hard sometimes to contemporaneously listen to what is being said in court and talk. But the court was like, I'm not going to violate you. What he means is that he is not going to try to find, and this hearing is not for him to try to find Ann Taylor in violation of the non-dissemination order. He is trying to find, it seems that they're maybe not clear on this, but whether or not the questions in the survey violated the non-dissemination order, and the survey needs to be stopped. And then if there need to be comparable surveys, then all the surveys need to be redone. That's where we're at.
With Dr. Edelman not getting the order. One of the things I think that maybe you need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record?
I'm going to see if I can gain this up just a little bit more on the audio, because he is awfully quiet. And I want to gain it up enough that we can hear, but not so much it gets fuzzy. That makes sense. All right. Hopefully this is better.
Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay. That's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree.
So the court, this is actually tremendously important, which is why I paused. The court is saying, look, for the purpose of the non-dissemination order, and he didn't say this in this many words, what matters here is, quote, what's in the public record. He is defining what's in the public record as what is in the court record. What are in the public court documents? And Taylor and her expert are defining what is in the public record as what is in the public realm, what is in the media, what is known in the media. So when we're looking at a question like, did you hear that Bryan Kohberger stalked his victims, which was one of the questions asked here, or stalked the victims, then that's not in court documents. We've gone through all the court documents. That's not in the court documents. But the defense is arguing that that's in the public record because it's been reported on by the media. And this is where I think we should just go to the expert, Your Honor, so that we don't have to guess.
Agree with that. No?
No,
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions.
Nope.
So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the
Not the question about stalking and not the question about following on social media. Those questions came purely from media speculation. Those did not come from anywhere in that affidavit at all.
dissemination order, if that's what we're going to talk about today. But I think the court should hear from our witness
I agree.
and understand a little bit more about this survey process.
Okay.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this. But so you're saying that the public record, though, comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media.
Ask the man who wrote the survey, because some of those questions came from the affidavit. Some of them did not. And I understand that there can be a valid point for that for the defense, but that's not true. Not all of those questions came from the probable cause affidavit. They absolutely did not. I'm so glad we heard the questions on the last hearing.
In this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated.
Yes.
When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Well,
okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record.
yes.
And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, Mr. Thompson is talking about, though, is information or questions that were not.
Correct.
And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides. But if there's information in the slides that are not in the public record, that really have not been disseminated generally, then, I mean, I don't really want to spread it. None of us want to spread it more.
This is
necessary.
why the judge doesn't want to just throw the guy up and let him testify, because there are questions that were asked in that survey that did not come from court documents. And so the judge is worried that doubling down on that is going to continue to take the shit that's out of the horse and spread it everywhere. So that is why Judge is like, I'm nervous that we're going to make this worse.
Well,
Shit's out of the
last
horse.
week in court, that was right inside the courtroom. That all became part of the public record.
Yep.
The 9 questions were stated repeatedly in different formats by Mr. Thompson.
Yep.
That's part of the public record.
Yep.
We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
Huh.
I understand that. I'm pulled in 2 different directions.
So what do you
right
do
now
about the
because
PCA though?
I'm trying to protect your client at the same time.
So is she.
So if we keep talking about this, what is not true, okay? I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know. Tell me. Maybe.
Well,
I'll hear this from
She was
the
making.
expert.
She
I'm
must have
gonna
been.
say it.
She must have been making a face that is hard to see over Zoom, because he's responding to her standing there being like, I imagine, pursed lips, going, "You're not hearing me." Like they are not communicating well at all at the moment.
Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better.
And that's fair.
And that's what I want to do.
That's fair. And you have to hear from the expert to decide, because she's saying, look, I can run this motion, but then she knows exactly what judge is going to do. She's going to run the motion and say, we cannot get a fair trial in Latah County. We know that's what's coming. That was in the expert documents that were already filed, because that survey's done. What she's going to say is, look, I can't tell you where's better if you don't let us finish the survey. So you're going to say, okay, fine. We can't have it in Latah County. Where to? And she's not going to have an answer. She is anticipating you're going to ask me for an answer, and I'm trying to provide it.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes
We
that
know
every
how you
person that is
feel.
called has heard all of the media in this case.
That's true.
And we know that that just simply isn't true. So
Can you just ask the guy that did the survey though, sir? He's like, it assumes this. The guy who did it is there. Let's just ask him what it assumes.
for those citizens in this county who have not heard all of the rumors, who have not been following the media, who
The
haven't
rumors,
inspected the court record, who
the
are essentially
innuendo.
ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true.
Your Honor, the shit's out of the horse and they're feeding it to potential jurors. Your Honor. That's where his argument is.
Some of it which would not be offered in court, and in fact, probably wouldn't legally be admissible in court to somebody who may never have heard them before. That's the state's concern about the way this thing's put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked, and by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case.
Then ask the
It
expert
could
why.
affect their ability to sit as jurors.
I
It's just
agree.
simply irresponsible. It doesn't make sense.
Then ask the expert. But you have a remedy, counsel. I'm just saying. You already talked about just excluding those people that were asked from the jury rolls. Here's what the prosecution's pissed about, I think. The argument he's not making, because he's not going to, and these attorneys have been very good about not flinging arrows directly at each other the way that's happening in like the Baldwin Rust cases. He doesn't want to say Ann Taylor has created the problem that she is going to then complain of, and she is going to say the jury pool is too biased, so we have to move. His argument is, but did you bias the jury pool? And the expert, I think, can clear that up.
This is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court.
I wanted to answer this question in the chat real quick by Judy M, and then we're going to let it roll. Isn't it a not balanced survey? If she says this will show bias, shouldn't she say if it indicates bias? I wanted to address that, Judy, because the surveys are already done. It's my impression from what the expert filed in the filings we covered, not the last time we covered this, but the time before, that the expert finished the surveys in Latah and it already reached a conclusion. So she already knows the conclusion the surveys have come to. So it's not saying, hey, we think this will show. She now knows the result, and we know the result. It was in the filings.
But to just send a
But the attorneys
message
are
out
mad about
to,
this.
to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
You're way too happy about this hearing, Your Honor. You're as happy as I am that we're in court again here. Look at him. He's like, this isn't the trial, folks. We know.
that's right. We may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process,
Can we just
which will
talk to him?
answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work.
Yes.
He's the one that's the professional. He's the one that knows how to do this.
Agreed.
He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Yeah.
There's no question I'm going to let him testify.
Counsel Taylor, I think the judge is an auditory processor like me, and he is still trying to redefine why we're here. So he wants to hear from all of you about what he needs to decide, because he's trying to determine what he needs to know from the expert. So I feel like the judge is me sometimes. And he's like, I just need to talk it all out so that I'm really clear on what we're all doing here together. And Anne and Bill are like, John, what the fuck? Can we just hear from the expert?
I just wondered about what's in this.
He wants to
I
talk.
haven't looked at this, but it's,
Yeah.
you're comfortable having this come out into the public?
Yes, after
She's-
last week's hearing, absolutely.
She's like, shit's out of the
Okay,
horse
and you
now,
looked
buddy.
At it, Mr. Thomas,
You have
is it
concerns, Judge.
alarming?
Well,
Bill, you read all the survey questions into the record. You extricated that shit.
part of what's in there is a part of the survey study being published now. If this comes to the public,
It's going to be
without
published in their
any
motions.
comparison to anything else, and it's the product of these loaded questions.
I'm squeaking. You made the motion. You made the motion to stop the surveys in the other counties, though, Bill. You made the motion to stop the surveys in the other counties. So you can't turn around and complain and say they don't have anything to compare it to. You told them they had to stop. God, you, sir. What? Nope. No, Bill.
It takes us back to the fundamental issue of how this survey was conducted
Bill,
and the assumption
you
that the
should have
people who were
stopped.
being called already knew all this stuff.
You should have stopped while
And
you
so
were
it didn't
ahead.
hurt to specifically ask them, have you heard about such and such and such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core
You said it in
concern
court.
that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern.
Ask the expert.
And Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received day before yesterday
Bill's mad.
is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in a discussion with defense about maybe some middle ground, but the line has been drawn
There's
black
not
and white.
a middle ground.
I am concerned
this
about
point,
the
Santa.
specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record.
Bill, I get it, but like you kind of gave the horse a laxative last hearing when you read all the survey questions into the record. And I'm not faulting you for it as a legal commentator. I'm sure Ann Taylor wasn't thrilled. I'm sure her survey company wasn't thrilled, but it is now on the public record. The gamesmanship behind all of that has a lot to do with him filing things under seal and then her not filing things under seal and then him being pissed that she didn't file things under seal when he filed things under seal. And so they're all like, Dad, he's touching me. And fine. If you didn't file it under seal, I'm not filing it under seal. So now the shit is everywhere. This is the game that all of y'all are playing, but you can't now complain that the shit is on your shoe because this is partly on you too, that the survey's not complete because you asked the court for an order to stop it. So don't go into court and then complain that it's happening. Sir.
Baked fashion.
I have lots of concerns.
Me too.
We're not left with this because
I just want to know everything at this point. Let's just
to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision.
If I was Ann Taylor right now, I think I'd have smoke coming out of my ears. What do you need to decide? You told the defense last week you were going to hear from their expert. Why are we re-arguing? Just hear from the expert. We're going to be here all night.
I need the information, so they're just going to go ahead.
I think she
All
must
right.
feel like the judge is
Take it, Randy.
backpedaling on what he said.
You can show your slides, and if something is
The slides just aren't going to be published. That's fine. Don't publish them.
concerning.
She doesn't care.
We can talk about it.
She doesn't care.
All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Edelman.
He's like, I think you are. She's like, I've been the fuck ready.
Okay, Dr. Edelman, if you could please come forward.
I'm
Face the
frustrated
clerk,
for
raise your
her.
right hand.
Oh, chat.
There you go.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, thank you, sir. Take your seat there.
We have a new
And then
layout.
once you're comfortable.
We get to see the
please
PowerPoint.
state
There's
your
a
name
witness
and spell your
cam.
last.
Oh boy.
It's Bryan Edelman, Bryan Edelman.
Thank you. Ms.
Thank you.
Taylor.
Good afternoon, Dr. Edelman.
Good afternoon.
What do you do for a living?
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
Can you let
What do
me
you do when you're a trial?
Can you let me produce this? We would like to see him until he starts referring to these. Anyone?
Consultant.
Anyone?
So as a trial
Anyone?
consultant, you're an advocate for your client. You do mock trials, focus groups, to really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury.
Oh, they
We
just
also
started.
do jury selection. I
Just started.
assist with writing voir dire questions, juror questionnaires, help ferret out bias during voir dire, recommend cause challenges and how to use peremptories, do post-trial interviews. I do jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an
Can't you just designate him as an expert? You filed a 9,000 page, I'm exaggerating, CV. Like we know all the things. We can't see the court at all. No, the court switched it to just this.
expert in the field of change of venue, does that differ from your work
But I
as
need
a
to
trial consultant?
Absolutely.
I need to see you
Well,
or I
as I
can't.
mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are
This is
retained
so
to
much
be an
harder to listen
objective
to.
expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue. Whatever
I know. I think we could
data
put the
supports
PowerPoint at the bottom.
where I go.
I want to
He's-
understand a little bit about your educational background that allows you to do that.
Can
work.
we,
How were you educated?
this is not to a jury. Can we just agree on this? Because you filed all of his CV. Why do we need to do this?
I'm sorry.
How were you educated? What degree?
Starting in
He's-
grammar school.
He's got a
Um,
bunch
we
of
can
them.
skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. My particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury
We know.
decision-making, group dynamics.
We read the
How
whole
people
CV.
process information and evidence, the impact on pretrial publicity,
It's very
pre-existing
interesting.
attitudes, and that sort of thing.
I hate
The
this
school
color
I went
scheme.
to really focused on that area.
I
That's
don't
where
like
the
it at
National
all.
Judicial College is, the Grant Sawyer Center for Justice Studies, and several professors in that field. So I conducted research at the Grant Sawyer Center for Justice Studies. I helped run a program through the Department of State that brought in judges and attorneys to the United States, where they would travel around the country to meet with people in their field. So I worked with the National Judicial College in that regard as well. And then from there, when I finished my PhD, I got a Rotary Scholarship to study in the United Kingdom, where I got an LLM in International Humanitarian Law, which I do not use.
I know. I liked the three
During the course
frame
of your
view
career,
better.
have you been published?
I have. I've been published in the
I would
area
like to.
of survey methodology,
The court.
Um,
What are we doing?
My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book
The
that comes out every year.
CEBs
It's kind
are
of like the Bible
so
for criminal
good.
procedure, and I'm a co-editor on the chapter on change of venue.
Really?
I was also on the committee for the American Society of Trial Consultants that
The CEB books are
publishes
so
professional
fucking good.
guidelines for writing
10 out of 10.
change of venue.
Mad
service.
respect,
So on
sir.
that, and I've also done
But could we,
research on one of the questions is always, well, why can't we just pick a jury in a high profile case? So I've done research on
Sir.
the use of the set aside question. So if people have been inundated with a lot of prejudicial media coverage,
Oh no,
how do they
that's too
respond to that set
fast.
aside question? Do we see, for example,
I
if
think I could.
somebody's been exposed to a lot of prejudicial coverage,
I think I could have sped him up if I could see him, but I can't follow him. Darn it!
you'd expect them to say, I cannot be fair and impartial. I know too much. And so we're looking at research.
I know that we're stuck with
And
what
then
the court gives
lastly,
us, and this is what the court is giving us.
I've also done research on what's called
It's not
minimization
giving.
language. So when you ask people an open-ended question on a juror questionnaire or in voir dire in a high-profile case,
And this is
the
important.
only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with.
We are getting to the meat of it, though.
And that's like using language such as, I only recall what was in the paper, or I just followed it. I just remember it was on the news. They don't really elicit a lot of information. It's minimized knowledge. So did research on that too.
That's been part of your research.
Yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you
Hold on, let
start
me move
in that
me.
role as an expert for change of venue?
Yeah. So first of all, I've been doing this for about 15 years, I'd say, as an expert witness on this area.
I'm moving me
On
so we
change
can
of
read it better.
venue
I'm changing it.
Specifically? Okay. And to do with surveys, just to be
Yes,
clear.
yes. From some, it's surveys, other times it's post-conviction, once again. I've done it federal cases, state cases, multiple states, including Idaho.
I just don't know if we need it full screen if we can't see anybody, so we're going to do it like this for now.
But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field.
I'd rather see court
he worked on
too.
cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Is really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include?
That is not my mouse on the screen, by the way. Just I needed you all to know that that is the mouse of whoever is controlling the PowerPoint screen. I'm distracted by it too. I can't control it.
Inadmissible or misinformation. Now, just because it's not true does not mean people don't see it, and it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be.
Directly
For
addressing
example, if there is
the prosecution.
a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe they're victim impact statements where victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at.
It might be like this for
political
trial.
elements that are important in high-profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury.
That's
and
fair.
that is the question that matters most. what impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters, because they develop opinions and attitudes. And it doesn't make a difference if that fact's true or false.
It sounds like he's very animated in the way he's speaking. I sure wish we could see it, but we can't because of the court choosing to just do the PowerPoint. Because it does sound like he's very animated. He was in there the entire time the prosecution and the defense were arguing over whether they would be arguing. And so he is trying to address that for his work, it doesn't matter if the information that the jury pool might be exposed to is actually true or false or whatever. It matters if the potential jurors have heard it and if they're swayed by it.
They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey.
I know.
And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered voir dire. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of name.
Okay.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper.
The court chose to.
I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here. And
Hi, Bill.
I don't think that's appropriate.
These
These
slides aren't needed. What? We don't care about the PowerPoint.
Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
The slides are not.
Well, you've seen the slides.
I have.
You looked at
But
them.
everybody else here hasn't.
Bill, they're being broadcast on the interwebs.
It's just
so.
an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid that there's no foundation for, Judge.
Well,
Sir, really?
It just seems highly unusual.
Well, hold on. I'm viewing him as an expert. Okay?
Yes, sir.
He's explaining what he does. So I'm going to.
No problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
Bill didn't get the slides, Rob, until they walked into court. No, I think he said he got them at some point earlier in the day. So he must have reviewed them at some point, but he's annoyed by it. Clearly.
All right.
I'm sorry.
Yeah.
Frankly, I've never seen
No,
something like this occur.
That objection. I mean, this is not.
They're demonstratives in a non-jury hearing. Like, these are the slides we're fighting about, because this slide has nothing of help.
Not necessarily factual. It's just an example of how he got to.
It's an
where he
outline.
got.
It's like
That's
a
his
bullet
testimony,
pointed
but
outline.
The PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
Sure. Let's see
You
him
wanna
instead.
Respond to that.
I do,
Okay.
Judge. This is a courtroom demonstrative aid that
Hi,
helps
Fred.
to track the testimony of
We're not-
Dr. Edelman.
We're not frustrated.
I can hand him my computer and let him advance the screens if
Sure.
that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Thank you.
Bill,
Go ahead.
that was kind of the point.
Dr. Edelman, we were talking about where you get your information.
We were talking about the what?
Where you get your information. What media do you look at?
I'm waiting for him to be like, this photo has no foundation. We don't know what newspapers those are. We don't know where they're coming from.
I think that's where.
Yes.
These slides are
So
not
I take a conservative approach to how I do it.
helping
I
anything.
look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas, because I don't know if somebody in Latah County would be looking at a paper in Dallas.
Fair.
So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
I think that's appropriate.
While we're here, I want to ask you some questions
was-
about the non-dissemination.
This was all in his
Okay.
filing.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
He is now.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics
Oh.
of media coverage.
Yes, it was.
Discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And
Chad, I'd
in
prefer to see court too.
January,
I don't like this.
did you receive an email from my office with the non-dissemination order?
I believe I did.
And you
So the defense gave you the non-dissemination order. Okay.
looked at a hard copy again recently.
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you even though
Does the existence of the non-dissemination order change how you did your work?
He's like, no,
No,
not at all.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
He's like, a lot of high profile cases, in fact.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used
Packages.
was widely disseminated through the media.
Okay, but
Widely disseminated.
Did you find out where the media got the information?
Yes.
Did you find out where the media got the information? Yes, Bill. Okay, roll the video, I guess.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up.
I can't hear.
Kohberger,
Well, Your Honor, the thing about volume is, let's all try to turn up the volume. Well, the court's trying to turn up the volume. I'm just going to max out our volume
Yeah, you don't have to.
because I don't think it's going to get screechy.
If I put the microphone up, is
Oh,
that
no, it sure,
better?
sure fucking did. Oh,
Yeah.
God.
So, yeah, but Christy, you don't have to type things that are recorded here.
It's about the best we can get.
and let me preface, there's a pending case now in court. And I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners.
How was the affidavit so widely circulated, expert? Well, Bill said share it far and wide. That's the answer.
And all the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
And
In that clip, you heard reference to the probable cause affidavit.
Yes.
And did you hear reference to sharing it with all your readers and watchers?
Readers, watchers, and listeners, and anyone else who's interested.
he did also say so everyone can have the facts.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes.
Good afternoon, folks.
What did you see?
Basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit, there's editorial.
I read the affidavit. I did also give commentary, but I read the affidavit. We read every word of the affidavit.
There's debate, there's discussion, there's spin, all of it in news stories. And these stories, for example, this one has over 200, I'm sorry, I can't see it.
It says 130,000 views on YouTube and 244 comments. The comment section is actually fairly low on that. Now I see why when the court's like, are you okay with the PowerPoint being shown? Anne was like, yes, sir. Yep. And Bill was like, no, we don't need any of this.
Copy of the.
I mean, the press release, the press conference is still
I
out.
do, Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory.
I just can't see it.
Sure, just go ahead.
Okay, thank you.
What are we doing?
This one is on a local television station.
They were showing the expert a printout of his PowerPoint so he could see how many views this video had on YouTube. I don't know if it really matters all that much.
On YouTube alone, 130,000 views and 224 comments. So
Are you
people
impressed by
discuss.
that?
That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source?
I don't anticipate being in any of the slides because he is focusing on local news media. And he is very heavily focusing on media out of that area, but I wouldn't anticipate seeing our coverage there.
And see that it continued to be shared.
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document.
Yep.
To later saturating the community with prejudicial details from that document, which was reported in the press conference to be truthful as well. 54,000 views, 176 comments on just one other video of a news clip on YouTube.
From which,
And based on your research, did the story or stories continue to be shared far and wide?
Yes.
Janelle Finch is joining.
Cases received massive media coverage, saturating.
sir, Foursquare? Foursquare? And Flickr? Sir, can we update this clip art?
This county with prejudicial pretrial rules.
How about to social media?
It still says Twitter, sir.
It was also spread through social media, and people have talked about it on social media.
Why is Flickr and Facebook so prominent? Why is the Instagram? I'm so distracted.
And do you know if misinformation and rumors ended up
These are leading questions.
as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this.
The TikTok psychic case, that goes to court next week. We're going to talk about it next week, but the TikTok psychic case has made it into court. Y'all.
Other references to questioning the implication of people knew about the crime before it was reported to the police and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in small communities such as this.
Yeah, I agree that social media is not local media, but this seems to be like he's in it looks like a university Facebook group. I'm going to tamp down the audio just a little bit because it is getting a little bit distorted. It sounded like they moved the mics, but we can't see court because they only want us to see the PowerPoint. Why do all these experts love the rippy edge pages. I hate it so much. But I did not have TikTok Psychic on my bingo card at all.
Did your review of all of this
That's
information
better.
tell you as a professional, as an expert in your
These are
field,
leading.
that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
No.
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979, Constantinian King in 3 cases in Yolo County, California.
Yes, there is a county in California called YOLO.
This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, has been using it for decades, 40 years or more. Other experts in the field do it. John Walker, in the American Taliban case, they used a similar approach that was published as well. Used in skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is. One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on juror and jury decision making. One of the things it tells.
I'm very interested in the science, but I also am really interested in how many of the law nerds have connections to Yolo County. So shout out to Yolo.
For example, is knowledge. Let's take a step back. People who regularly watch and listen to the news are more likely to know about the case. When I say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have, and then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding a defendant's guilt or innocence. So those are some of the findings, and we craft the survey similar to the others because we want to test the validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of the survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code, how to conduct surveys, venue surveys.
Impossible Princess, this is the defense's witness. This is the defense's expert. We're not going to see a responsive witness. We're just going to get a cross-examination. This is just supposed to be to determine if the surveys will continue, what questions will be on the surveys, or what remedy needs to be taken if the judge finds the surveys to be a problem in Latah County, though shit's out of the horse, not much you can do. But this is the defense's hired expert.
Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times.
Graphic design is not his passion.
About it. So that's kind of the basis of how I craft this.
And I heard you mention standards and validity.
Mm-hmm.
Why are there standards? Why does that matter?
Why are there standards?
I'm sorry, why are there standards?
What is science?
Well, one is you want to make sure, as we learn more about research in human behavior, we learn more about what you should and shouldn't do. So, for example, there's something called social desirability. People want to create a positive impression of themselves. So when you ask questions, for example, can you be a fair juror? Well, we all want to be fair people, so you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was a election for governor, I think it's Davis or something like that, and all the polling suggested he was going to win. He was African American, and he lost. And that was when they started looking at that, and they saw all these different impacts in terms of
It's not my mouse.
race of the interviewer,
It's
all
Taylor's
these things
mouse.
affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. People overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
Everybody who gets anxious is like, stop it. You're calling me out. People don't want to be called and be like this, that. They don't want to be contrary. You have their number. Like, it used to not be weird when people called me on the phone, but if you call me on my cell phone, it now feels like, why do you have my number? And do you know where I am? So I understand that people might want to kind of go along to get along in the answers. That's why he's trying to break down the need for the specific questions. I get it.
In your survey, it looks like you have sections designed
Can we
in
see
your
the
survey.
sections?
Sorry, can you hear me? Okay.
Better with the
Fred, what are you
microphone.
trying
Okay,
to do?
I'll try to stand closer over here. I want to understand this section, these sections. Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be
She said sections 7 times. How is your answer sections, sir? We can't see your face, which makes all of this difficult. But
jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confused.
Fred just yeeted the goat off of my desk. Like, yeeted the goat. Fred.
Potential order effects. So we try to organize the survey into sections. So all of the key questions on one topic are together, and then the next section changes topics. So it's easy to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that.
Did you read, see, or hear that Bryan Kohberger stalked the victims? That's how are you deciding that's not prejudicial?
That case. So if widely reported
I have
A,
to
B,
find
and C
Vincent.
facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on the fact.
Do you just stop?
We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question and they continue.
It's like me when I talk to you guys about the Corey Richins case, and half of the chat sometimes goes, we're covering a lot of cases. Which one is that? And I'm like, fentanyl and Moscow Mule. And y'all are like, that one. Gotcha. That's what he's trying to get to.
If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we add based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
Case.
I want to make
specific.
sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never.
Never.
Do that. Then they're asked how often they follow the local news. And then
But do you mean like online? Because I don't read a physical newspaper. Like, how do you define newspaper?
ask a few demographic questions like age, gender, race, ethnicity.
But how do you find newspaper?
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
I have on the screen in front of
Well, there's the questions that the prosecutor was talking about last week.
me some of the read, seen, or heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage.
How did you choose the number 9? And is it because of the movie Ferris Bueller's Day Off? And if not, why not?
That were widely reported. Let me be clear, widely reported hundreds and thousands of times.
We did a poll in the chat though, and the first questions chat had heard. When we got to the later questions that were less grounded in the court documents, it was less than 50-50. So the things that are grounded, these are grounded in the probable cause affidavit. More of chat had heard those, and this is chat that's following this case. When we got to the things that were less grounded in the court documents, less people had heard about it.
And potentially prejudicial items, because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial. And it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pretrial publicity that has been recognized by the Supreme Court, I'm sure the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again,
wait, where'd the rest of the questions go?
Throughout the media, thousands of times.
They skipped the rest of the questions.
Yeah, just to be clear, you gave an example of information that might be widely reported that's high.
I wonder if that was strategic that they skipped the rest of the questions, because the rest of the questions are the ones that were not super based on the PCA. That was
prejudicial that you would use in a survey. You haven't talked about Bryan Kohberger's survey yet, have you? You haven't told us the 9 questions.
I have not.
Okay.
We just saw them.
And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades, and I think you told us a little bit about some of the other really high-profile cases where this survey format, the survey method that's been widely accepted, was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho.
But using it in another case doesn't mean that this judge is going to agree with you. Like, I get it. This was all in their filing.
The Jonathan Renfro, which was here. State of Idaho, the Gilberto Rodriguez.
Anyone surprised he hasn't worked on the
and many
Daybell
others.
case?
I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have. Other experts in the field do it. This is the standard practice.
Standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing?
I find the examples of questions in other cases to be helpful. Let's see if Judge does.
These surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in a
Yes.
case that you worked on.
Yes, this was the Jason Van Dyke case in Chicago.
Did they agree to you disclosing the survey, or is there confidentiality with your prior clients? I have some questions about that too. I'm interested in seeing it, but like the first question in my mind is like, okay, but are you allowed to disclose that?
He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential
Okay.
bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case.
Okay.
Earlier, you talked a little bit
Oh
about
my God, the white
validity
background
being
of this
one of the
slide is
standards.
painful.
Yes,
Tell me how you measure validity in one of these surveys.
sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned,
This was all
we
in
want
his
to look
report
at
that we
things
read.
like consistency.
Well, this
So we
part
want
was,
to,
the last
for
part wasn't.
example, the research tells us the more case or media items you know, you develop knowledge. And the more you know, the
Did you
more
just
likely you are
say
to
the
exhibit
more you
bias. So
know?
I want to test that in the survey. That's one of the reasons why I include
They're
those
now peaking
case-specific
more,
items.
or I'm more annoyed.
I also want to compare what people, or that item to prejudgment. So the more people know, are they more likely to prejudge?
The
How
more
about case-specific
you
media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, so I've had this happen in a case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail, and is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case? The open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And that's the type of problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
What, Fred?
That's one of the reasons, absolutely.
You
have
heard
attention,
talk
and then you don't
last
want
week,
it.
and then you've heard it
You
again
have attention,
today about,
and then you don't want
can't you
attention.
just change this survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well.
He feels like he's trying to tell Santa, this is based on 15 years of doing this. Why are we having an issue? He does not sound happy.
That when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. Have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks, and maybe a bunch of other stuff. But I am very confident that you would miss
maybe a bunch of other stuff. You underestimate us, sir. Don't tell us the odds. We have now been underestimated. I'm curious to what he's going to say, though.
And Ewoks, and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? You'd probably say, yeah, of course, I knew that. But you didn't mention it in the recall question. There's a mountain of research on this.
I would have to just say, how much time do you have? Do you want me to go in release order, chronological order? Are we including like the entire universe? Can we like bring in the Clone Wars? Like, I need more parameters. Also, don't threaten me with a good time. I'll talk to you about Star Wars all day long.
What they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question, is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need
How
to
much
know,
more do they know?
what do people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias?
I don't disagree that they might be important, but whether or not they violated the order is different.
80% of people are able to recognize a prejudicial detail. And I keep making up because I don't want to upset anyone here, like a prior conviction.
I just need to see people's faces. Judge. We need to see people's faces. I want to see if he's looking directly at the prosecutor when he's like, I don't want to make anyone upset here, sir.
If 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury.
Oof.
Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in this survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard if X, Y?
The stalking, was it the stalking? Was it about the stalking or was it about social media? Because those are the two things that were not in court filings that I recall off the top of my head that you were talking about. And he said 3% said that. And then he read them the question and then what?
And Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment. People who knew it, over 80% of them think the defendant is guilty compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Have you had a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yeah.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Hidalgo County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So
what? I now need to know everything. The crime happened in the 50s. The trial happened when?
And the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved in the fabric of the community. It was so shocking. And during the hearing, after doing the survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college I learned about this case. So I know A, B, and C. And we say, hey, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning the well. And we asked, for example, did you know that John Fight gave a confession to a priest? Confessed to the crime. Oh, yeah, I knew that. And once she said that, it stimulated her memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana and a bunch of others. And she knows that. And then we asked kind of again, is that everything you know? And she says yes. And then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh yeah, yes, I do remember that. Once again, she knows a detail that she didn't mention. And Redford saying, okay, and you didn't say that a few minutes ago, did you? No, that's the second one. And then we asked, having refreshed your memory, are there any other facts that you have read, seen, or heard that you haven't told the court? And she's, I don't believe so. It seems like that's all she knows. Then we tried again, and we mentioned that he had been.
These are court transcripts. These are clips of court transcripts from 2018. So these would have been printed out, but that is the type of font that is very common in court transcripts. So these were court transcripts from the court reporter when they did this hearing in court that included the mock voir dire for their motion to change venue.
And transferred to another monastery. The Catholic Church was moving him around. And she knows that too. Oh yeah, I did do that. And we tried again. Did you know that local law enforcement were participating in a cover-up? That was part of the story. Yeah, she knows that too. So this was an example.
But how much of that is also, I just want to know for me, how much of that also is people going, oh yeah, I might have heard something about that.
Example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? What have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile
Rob, it's
case.
interesting.
In general case, it doesn't matter because there is no case-specific information.
My
What we
neurodivergence
know
wants
is that specific attitudes
visual
predict behavior much more than general attitudes. So a community like this has been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias. And are we able to ferret out that bias in jury selection? And that's why we include those questions in our survey.
I want to talk about Bryan Kohberger's case for just a minute.
it's hard
Connor,
to,
again, I'm gonna register the objection. This is
it's hard to listen to people talk without seeing them. But I agree with you, Rob. It is very interesting, and the court needs this information.
this is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze, much less
You've made your record.
much less respond to it. So to the extent the court wishes to allow this to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Yeah, okay.
Okay, thank you. But you'll have an opportunity to respond to any of this before I make a decision.
Not today, Judge. This goes. I'm sorry.
Hold on.
It would be so much easier if we could see all of you. Not today, Judge. Not today, Judge. Oh, he just like Santa not today, Satan the court. Not today, Judge. Again, I think we have a miscommunication here, because Bill's objection, and since Anne's calling everyone by first names, I'm also joining in that trend, just to keep with the local vibe and feel of this courtroom. So Bill said, I have an objection. This is starting to get into what would be the motion for change of venue. And we are not prepared to respond to the motion for change of venue that hasn't even happened yet. The defense has not done their briefing. The state has not done their briefing. The defense has not done responsive briefing. They have not had a hearing. None of that. And the judge responded with, well, you'll get a chance to respond later. And he's like, we're going to have to clip it. I'm going to need this on my soundboard. Not today, Judge, because he thinks the judge is talking about the motion to change venue, not about these surveys. And I think, again, they are misunderstanding each other, but it's hard to tell when I can't see their face. But I'm going to have to clip out the not today, Judge, and put it in the soundboard. It has to happen. Not today, Judge.
Okay. Thank you. But you'll have an opportunity to respond to any of this before I make a decision.
Not today, Judge. I'm sorry.
Hold on.
Yes,
I'm
sir.
not going to make a decision today.
Yes, sir.
I'm getting information,
Yes, sir.
and then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that. Two separate issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided. We have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Y'all aren't hearing each other.
Thank you.
Y'all aren't hearing each other.
Thank you. Dr. Edelman, you haven't finished analyzing the data in Mr. Kohberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items.
You haven't finished analyzing the data. I overrule my prior statement and withdraw it that Ann Taylor already knew the results because it seemed to indicate in both his prior motion and her statements that he had analyzed this and decided that there was bias. And now he's saying he hasn't even analyzed all the data. I find that very interesting. Very interesting.
Why they're in the survey, which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
Well, you've already.
Well, I do, but I'm not done analyzing the data.
Senate, I want you to be informed before we get there. So I do want to talk, though, about Bryan Kohberger's
He
case.
said, I don't have it. Well, I do. Well, I do. It's like, I don't have it. Well, I do. I haven't finished analyzing the data. It sounds like he's already come to a conclusion.
And if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research, and here we find similar findings, and we did. So we also look, for example, do we have like acquiescence bias? What that means is people are just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention, everybody knows about. So you see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the
I'm looking at y'all's
recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, as I mentioned, those are the case-specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media.
Sasha, Sarah in the chat, and a few others. We are a few minutes behind on court because I'm pausing to talk instead of talking over court. So once we run out of the PowerPoint, we will be on live witnesses. It is not the different view during this part of the hearing. It is that we are a little bit behind because I keep pausing to talk. So when we catch up, we will be able to see
these details,
but not till the PowerPoint's done. Because I've scrubbed through the
more details
feed.
you know, are you more likely to be biased?
Back to the more you know.
But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize the case, you stop and you don't ask these case-specific media generated items in your question.
Correct. And remember, these media items also come after the open-ended, what have you read, seen, or heard about the case?
Which is helpful to know.
Do you know how many people did not know about Bryan Kohberger's case in this survey? The percentage?
I believe it was like 3 to 4%.
And so that percentage of people didn't get the case-specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case-specific questions.
I want to talk about
the people who didn't know about the case, the very few. Right. I imagine everyone has heard about the case in some way, but they might not know everything that you asked, and that's what the prosecution's going to ask on cross, I imagine.
Open-ended questions, and then the have you read, seen, or heard questions. On the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Where are those
so one of the things
reported?
we do is we read everyone, and we track how many details they mentioned, and then we compare them what did they say, to how many case-specific items they later recognized. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later, and how many of those items did he mention in the open? In that scenario, it would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open, then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
Again, how
You're
much time do you
checking
have?
what they say they know in the general open question, and then see if they hit some of the specific questions, and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story. I'm looking to see if that is a
This is a helpful slide. Thank you, sir.
problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew.
Wait, that says 4.9 though. Where'd the 6 come from, sir? Oh, here. Good.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case-related questions? They would rattle off, I know these things, several things.
Yeah, so what I found was, on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5, on average, out of 9, they knew, although they didn't mention it. And these are examples. So somebody wrote just what has been on the TV and the papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested. Someone else mentioned the detail. The kids were murdered and they tracked them down. Well, you actually know 6 out of the 9 media items that we tested. Nothing lately knows 7 out of the 9 media items tested. It goes on and on.
Nothing lately is super accurate. What do you know about this case? Well, there's nothing lately accurate. All of this shit came out over a year ago. So I don't think those are,
Very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm. What I see in terms of knowing more detail than they report. And it usually, interestingly,
that is the point.
The average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9.
And that is the point, that people know more than they're saying that they know, because
do you have
it
a way
seems irrelevant or whatever to them
to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to, because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't.
Fair, but it's true. Haven't seen anything lately is true, but I understand he's saying, well, I can't ascertain how much the jury pool's been exposed to, and they might be holding in their memory, but not really acknowledge or remember that they know. They might not access that information until the specific question is asked, which is literally his whole point.
Analyze that. I can't do anything with that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required.
And that's why the stalking question's in there, folks.
And how do you know?
Why ask it? Because what if he said it right there? What if one item is not admissible, is highly prejudicial, and is broadly known? That's why I ask it. Look, Your Honor, this isn't even fact-based, but all these people already knew about it. And if they have that in the back of their mind, then even if it doesn't come in at trial, it's a problem.
That there's prejudgment in a case. What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, you believe the defendant's guilty of whatever the crime is, and it's on a scale of like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from a judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then that's what, can you be fair and impartial? And they go, "Yeah, I think I could be fair. I can try. I think I can do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh yeah, definitely. It could be hard to change my mind." So I used that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If you didn't, you'd be creating order. So you have to do that.
Okay.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing for the same crime, and then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted him. Of course I think he's guilty. So if you included all those 9 items,
It can taint it.
and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So we would never do that.
So you ask them well ahead of case-specific questions. They have to recognize the case. They have to agree, I know of this case. And then you.
So my highly neurodivergent friends, what he is saying, for those of us that would like faces to help us follow along to what people are actually saying, is that they don't ask the impression of guilt or innocence after they ask the 9, have you heard, seen, or read questions. They ask it earlier on, then ask those other questions, and then correlate it back. This many respondents who knew this many specific items thought this, but they correlate it after. So
ask if they already have an idea of what they think of whether Mr. Kohberger is guilty or not in our case.
Correct.
And then you have the case recognition, and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I look at is the prejudgment question, right? That's on a scale, so Likert scale. And then I can look at things like, is a relationship between the number of details somebody knows.
Because I think he's just trying to educate the court at this point. Truly.
I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? Is there something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Bryan Kohberger's case?
Yes. So because we asked these questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're
very high recognition. It was a very, very big deal for this community. So I'm not surprised that there's a very high recognition. That isn't a problem unless you're Bryan Kohberger saying, well, if everyone here is thinking about this case and the people who know more details about the case think I'm guilty, then this is not a good place to have this trial, because it's going to bump up against the same problems in voir dire when you ask people, what have you heard about this case? And it's like, well, nothing lately, just the stuff in the media. But they don't disclose that they had heard that his DNA was on stuff, that he stalked people and whatever else. So that's why he's trying to get through the open-ended questions that you're going to get in voir dire to try to show why this jury can't be, he believes, in Latah County, which seems clear to me.
Undermining his due process rights. Everybody knows all this stuff. Very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
I thought you said it was 4.9 earlier. What?
Given specific case-related bits of information, these 9 have you read, seen, or heard questions. Does recognizing one of those questions, if that's oh yeah, I know that one, does that change the incidence of fights, or does that relate to I've already prejudged this case?
It does. And what's really interesting is kind of going back to the open-ended question. So again, I won't mention the detail, but there's one that was widely reported, it's in that affidavit. And 81% of survey respondents knew that specific detail.
Thank you.
81%.
Thank you, chat. That was like percentage
versus
versus number. Appreciate it.
However, on the previous question, what have you read, seen, or heard about this case? The open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question.
He doesn't sound thrilled or optimistic about this potential jury pool. He's
significant, and I can only do that analysis because we asked those questions.
Very fired
and
up.
72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail. So that's the kind of analysis we look at. What do these case-specific items look like?
That's what we were in the middle of.
If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the open? Is it consistent, or is it perfect overlap, or nobody talks about it, but they all know it? In another one, only I think it was 3% mentioned a specific detail.
Here's the question. Only 3% mentioned that they knew or had heard that Bryan Kohberger stalked one of the victims. Again, this was not in any of the court filings.
So that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth. 45% knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%.
I don't know how this question is anything other than highly prejudicial. If somebody believed that's true, I don't know how you get around that. If you believe that that's true.
People knew about it, but only 3% mentioned it when I asked the open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding jury questionnaires. This is the phenomenon that we see all the time.
He's like, because brains.
And the only way to look at it is by doing the surveys.
He's like, because brains.
Before I ask the question about courts relying on surveys to make decisions, using these surveys to make decisions to change things.
Jasmine, he said he hadn't finished analyzing the data, but he clearly has done some to be able to answer these questions, but he said he was not finished analyzing the data, and maybe she'll ask him more about that.
When you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that.
Chat, I love your discussions. Y'all are the smartest group of people.
Are you telling me that that's still going to be in my courtroom? Things that aren't true that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision-making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability or participants' ability to recall the source of information. And what they found is
me on members only this evening, which will be back up after all of this because I didn't want people to get caught there and then not be able to watch this. Me talking about my inability to recall things like case names, dates, or whatever. I can tell you all the facts of a thing, but the recall of names cannot do it. I'm fascinated by the way he talks about how our brains process and recall information. It is my favorite part of what we read in his expert witness filing. I find it absolutely fascinating, but it's also hard to hear his tone and not be able to see his face.
Is after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled and learned from the trial. So they assumed stuff in the media came out in trial.
Does that explain the reporting from Depp v. Heard? Does that explain the reporting from Depp v. Heard? He's talking about people not being able to recall what they saw in the media and what they learned from the trial. In Depp v. Heard, I think the media can't understand what they learned from the media and what they didn't learn from the trial, because we had media like LA Times reporting that Jason Momoa testified when they saw it on TikTok. So this problem is only going to get worse. And I'm interested to hear what he has to say about this problem is going to get worse as time goes on, especially as media can be more easily manipulated. There's videos of Diddy being arrested rolling around that aren't real. So this problem is going to become more exaggerated, which is why I'm so fascinated to see it here, because again, I don't have a stake in this game. I don't have to drive from one county to the other. I don't have to voir dire these jurors. But if the jury pool is so invested in this case that he can't get a fair trial, then everyone deserves a jury pool that can give a fair trial.
The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going to put it in a box in my mind and never think about it and process everything, and it's never going to affect me. It's just, there's nothing to support that. It's kind of in our everyday lives. That's what our brains like. Think about what's going on today with Trump and Biden and all that.
Brains.
Everybody has strong opinions. The idea.
Can we not talk about politics, sir? Can you talk about Vanderpump Rules? Like Ariana Tom, everyone has strong opinions, very strong opinions. And the cast is not backing up Ariana very well this season, I gotta say. But it is hard, unless you have been trained to think that way, to cordon off information and be like, I know this information, I feel this way about it, but I also need to process this information.
That, oh, yeah, well, it's not legitimate, or that fact is wrong. It's misinformation, so it won't affect me. There's nothing to support that. There's even research that shows you have people, they read a passage, and they write something supporting a position that was in the passage, and then you tell them that information is not true. It's called belief perseverance or belief persistence. And what they find is even when you tell them that fact is not true, they still have a difficult time not believing it.
Well, he called it belief perseverance or belief persistence, that even when disproven, it's hard to let go of. That's interesting.
Still impacts their views. They still defend it, even then. So there's a host of research on this. The idea that we should only test things that are factually accurate and assume that the other stuff isn't prejudicial is just ridiculous.
I need to see his face because I need to know if he's just really excited about what he does or if he's angry or both. I need facial expressions.
So a massive amount of prejudicial media coverage is a factor that has to be considered in a case with this kind of coverage. Is that right?
Yes.
I want to know, though, from your experience, have you done a survey like this that contained these 9 case-specific questions where a judge decided to change venue?
Yes.
Will you tell us about that?
Yes. So in Nichols, it was a case in Washington, and this is kind of what I was referring to. So it was a defendant who had been convicted in 2012 for murder, Grant County, Washington. Later, it was a high-profile case, and then later the conviction was thrown out. It had something to do with jury instructions or something like that, and there was going to be a new trial. And wait a bit.
Did you hear what he said, chat? Something with jury instructions or something like that. It is so often the jury instructions.
The time had gone by, like a decade. So we did a survey because that fact, knowing that detail, would be highly prejudicial. So what we found was 42% of survey respondents had read, seen, or heard about the prior conviction when we asked that case-specific media item. However, when we asked the open-ended question, what have you read, seen, or heard about the case? Only 12% mentioned it. So 12% mentioned it when you ask the open-ended question you use in voir dire, but over 42% knew about it. Now, you could never ask a juror, well, did you know a jury convicted him of murder if you didn't mention it because you're poisoning the well? And the court agreed and was worried about the effectiveness of voir dire as a remedy in that situation and granted a change of that.
What he's
Have you-
saying when he's talking about you can't do it in voir dire because you can poison the well, there are some ways around that. It's time consuming, but talking about poisoning the well is if you have a courtroom full of potential jurors, you have like 18 in the box, you've got the full courtroom packed with a veneer, and you ask one of them, so did you hear that there was a previous conviction for murder? Everyone in that room has now heard this information, and then that spirals. So that's what he's trying to say is you have to do the surveys because it's too late once the jury comes in, where what we saw in like the Murdaugh cases is they were doing that with the court surveys and they were starting to sort it out as those things were coming back to then follow up on it.
You have the opportunity to pay attention to any prejudicial media coverage since the hearing last week.
I have.
What is that coverage?
Since the hearing last week, keep reading, Emily. Have you noticed prejudicial media coverage since the hearing last week?
Well, it created
Anne doesn't like this headline about her.
misrepresentation, false narrative that we, myself specifically, had done something to wrong, to poison the well, taint the jury pool, and using language like that. That became part of the narrative.
As Rob has been mentioning in the chat fairly consistently, no shade, Rob, fairly consistently, this expert is defensive because he is listing it out to you. It is the narrative now that I did something to taint the jury pool. So that's what he's talking about. So we've been leading up to this. Rob has been pointing it out the whole time. Spoilers. Spoilers. Rob is here rooting for team court, like team law. Like, let's have interesting shit happen in court. Me too. We're rooting for court to court. But he's saying, look, I'm being accused in the media. And he comes in after having explored that.
Since the hearing last week.
I have.
What is that coverage?
Well, it created a misrepresentation, false narrative that we, myself specifically, had done something to wrong, to poison the well, taint the jury pool, and using language like that. That became part of the narrative. I saw it on Reddit, on social media, in the news.
Sir, don't go on Reddit. Don't. Rule number 1.
That once again, going into this idea of what the story was, that the defense had done something wrong, debate about whether it was part of their tactic to delay, get him off on a technicality and so on. And again, what I did, just want to be clear, is the standard practice in the industry done hundreds of times in high profile cases throughout this country. There's nothing I did to
So he's
contaminate the jury pool.
trying to
Everything I
defend
included
his name.
was widely disseminated
and
by the
reputation.
media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
My questions did not taint the jury pool. The prosecution said disseminate this far and wide, and that's what the internet did, because internet. That's why he's mad. He's like, and I am being accused, which is why myself and other lawyer coverage tends to be Kohberger attorneys asking questions, Kohberger attorneys communicating with the jury pool, not headlines like this, Kohberger's attorney in legal hot water for polling potential jurors, because that's not what happened in court. It's just not factual. It's clicky, but it's not factual.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why, is as I mentioned, my role is to be an objective expert.
You don't know what you're doing,
providing
Anne.
information so
And you're a lawyer, not a statistician. I wouldn't take your advice.
the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
I love how many researchers we have in the chat. Leonard is a full identity because we are very nerdy in lots of areas of our life.
Do you believe comparative surveys in other counties would provide the court with?
Okay, the source of the most prejudicial media items came from arrest affidavit, which the government chose to file unsealed with the court. This is where the shade is coming in. They are saying they believe most of the most prejudicial information came from the arrest affidavit. However, I find the stalking question to be highly prejudicial.
More information about what to do when you get to change a venue hearing?
Wait,
I
Runkle,
do.
you have a
What?
stats degree?
Because this case has received a lot of media attention
How did I
across the
not know
state.
that?
It's a national case.
Fascinating.
And depending on what the results are of the survey,
That makes
I'm
more sense.
assuming if we find that there's grounds for a change of venue here, that's the recommendation, the response will be, well, there's nowhere else to move it. Everybody's been cut saturated with pretrial publicity, so there's no need to change it. The point of the comparison survey is to address that question. Is there anywhere in the state where you could move it? Maybe there's not. I don't know. But that's the only way to.
That's what he's saying. I can't tell you if you need a change of venue because I don't know if this is a statewide problem, like the shit's out of the horse everywhere. So voir dire is going to be a shit show. Get ready to question these jurors one by one. And then I imagine he would recommend how to voir dire the jurors one by one and start to figure that out. So he said, if I don't know if it's better or worse anywhere else, I can't tell you if we should change venue or not, because why change venue if it's worse somewhere else? We're going to have to fix it another way. If the entire state is contaminated, you can't move it out of the state. So he's trying to say, I would like to know if it's the same, better, or worse elsewhere, but I didn't know that because they got cut off after they had just finished Latah County and they haven't had an opportunity to do the other counties, which is the point of the hearing today, 2 hours later.
Find out. And you have to conduct the survey in the same manner. I don't know if I just ask people what they know about the case and you get general, I just recall when it happened, but you have the same guilt rate. Do they know inadmissible details? Do they know about things from that affidavit? Do they have a lot of case specific knowledge, or is it just a general awareness of the case? Do they drive by the house where the crime occurred? All these things that make this county unique.
Did you ask that
you want to
question?
test for in other communities. So it's not just a question of general awareness. I need to know what case-specific information they have, what misinformation they have, what media items they've been exposed to. Do they have as much case detail and knowledge as they do here? All of those things. So that's why I would suggest it's important. Without that, the only thing I can do would be to collect the media coverage and assess, for example, like, are there fewer articles published in Bonneville County or Ada County compared to here? That's all we have. I wouldn't conduct a survey that I know is going to lead to misleading information. I'm not going to do that.
I'm not going to do that. He's like, if you want me to change the survey, I'm not doing that. Like, I'm not doing that. That's not how this is going to work.
Change the survey, would that go against the methodology
He's
that
like,
you use?
Yes.
Yes, if I change the survey and I don't conclude those items, I can't test. Well, do people know a lot of case-specific information
He's
that
like,
was widely
you
reported?
can't
Are
compare.
those specific items related to bias? Which items do they know? Do they know the ones that were all over social media or not? Like, that's the whole point of asking those questions. What you'll get is, well, I don't know much, but I saw it when it first happened. I remember reading about it a while ago, but haven't seen anything lately. I know the defendant was, arrested or whatever, or things like, oh, I followed it closely. Okay, great, followed it closely. Does that mean they know a lot? I don't know. I can't assess just from someone say, I read the news or I followed it quite a bit. That doesn't tell you anything. That's not meaningful information. So yes, you need to conduct it in some fashion.
I agree with
Last
you, Rob.
week, your professionalism, your work, your reputation was impugned.
Uh-oh. She's giving him an open forum to defend his name, which I wonder if that's part of why she wanted to go through the entire thing. I don't have any qualms with this professional. He made clear how he does his work, why he does his work. But this is go ahead and explain why you're not wrong.
I believe it was, yes.
If you're allowed, if the court says, okay, go ahead and finish these surveys, I want comparative county information, Are you willing to still work with us?
If we do it correctly, if the idea is we want you to conduct a leading bias survey to get results that we want, then no, I'm not going to do something that undermines my credibility, my objectivity, or do it in any way that's not consistent with the procedures and standards of how we use.
I don't think anyone's asking you to.
Thank you. I don't have any other questions, Dr. Edelman, but the state, right?
How late is court going till they're done? They're still going. We're a little bit behind, but they're still going.
Johnson, thank you. I maybe we'll start
Thank you for taking that PowerPoint off the screen. Why couldn't it have just had a fourth screen?
going backwards here, or from the back of the
I need
front
a
topic.
snack. Do I have snacks? Did I bring snacks? I might
I'm
have.
sorry if your feelings get hurt about us raising this issue.
We did not start off with, I'm sorry if your feelings got hurt. We did not. We did not. Santa. Oh my God. The expert already,
You were almost breaking down.
the expert's face. The prosecution, oh my God, I'm backing up. The prosecution just said you were almost breaking down a few minutes ago. The things we could not see. Oh my God. Oh my God. Okay, I'm going to try to shut up.
Thank you. I maybe we'll start going backwards here, or from the back of the front topic. I'm sorry if your feelings get hurt about us raising this issue. I see you were almost breaking down a few minutes ago when you were talking about slide number 33, slide number 31. That's not the intent, and it's certainly
dramatic.
I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told watching on a Zoom that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay. And yes, it doesn't matter.
I'm not crying. I'm angry.
And please go ahead and be as angry as you like as you continue your work with the defense in this case.
Oh my God.
It is a fact, though, that you don't know of the 400 citizens that were.
Santa has said not today, Judge, and stay mad. Like, Santa, it's a little heavy-handed, sir. You're the prosecutor.
Questioned on this survey, you don't know which ones of them did not already previously know any of the fact-specific representations in your questions. Isn't that true?
I do know because they answered yes or no to the question.
No. Oh, well, okay. Before you asked the question, you didn't know that. Isn't that correct?
That's correct.
And so somebody who hadn't heard.
Bill. Sir, before you asked the question, you didn't know their answer to the question? Yeah, correct. This is going to be feisty.
Heard the representation in that one slide that you acknowledged was false. Let's see.
Protein bar that I stole from my kid. Don't tell him.
You acknowledged false that
Travis,
Kohberger
if you're watching, I didn't steal this from you.
One of the victims. That's false. You know that to be false.
Which one?
That Ms. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew.
He's like, I was trying not to say that because it's really prejudicial. And the prosecutor's like, stalked. There was stalking. Did you? Oh, shit.
Stalked one of the victims. That's false. You know that to be false.
Which one?
That Ms. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew that was false.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you.
Okay. Fine.
Somebody was in the shower, Bill. Wait, there was a lot of fire. Why are we pausing? Bill, I just took a bite. Sir.
And just to follow up on that, early on in your testimony, you testified, I want to make sure that we heard this correctly, that inadmissible or false information can be the most prejudicial information.
He did say that.
It can be.
Yes. And your surveyors put that false information into the minds of people who were asked that question who may not have previously heard it.
And he's going to be like, no, the media put it out there and we need to know who knows about it because the media put it out there, not us.
Correct.
Correct. Relative
Thank
to
you.
the media, thank you. It's mentioned it hundreds and thousands of times.
We didn't. I didn't. We didn't.
And just make sure we're clear to, around the same time in your testimony,
Hi, Judge.
I believe you testified that you don't care if the information that you put in your specific questions to the people being surveyed is correct.
Correct.
You said that, didn't you?
Correct.
I don't know what you mean by correct.
True or false?
I care about whether or not it's proliferated by the media.
You don't care if it's true.
No, I don't.
No, because Bill, sir, are you missing the point of his work though? Because like the point of the work is to see what the potential jury pool knows. Because if the media is reporting shit that's not true, that's highly prejudicial, then they need to know that. How else do you discover that? I think the questions can be a problem too, but maybe the problem was the media reporting it first.
No, I don't care about it. It's prejudicial.
So it's okay to taint people who had never heard that information before for the end result of identifying others who have and might have bias. Is that a fair statement?
I'm going to object to the questions.
He can answer
He's
the question.
badgering.
Wait.
Let me finish my objection.
Yeah, it's an objection.
He's
Judge is like, this is delightful. And these attorneys are like, can you please stop?
badgering the witness. He's misstating his testimony, and I object.
He's not really misstating.
The witness testified he didn't care if the information was correct, Judge.
That's what he said.
Yeah, overruled. So,
May I?
so
Just slow your roll, Bill.
No, that's okay.
one person can talk at a time, and let's take down the tone a little bit.
Yes, sir.
Yeah, Bill. You sound a little pissed. Let's have a pickle cleanse. Let's all just take a deep breath. The judge might take away your coffee. You might have to work. You don't have to go that slow though, Bill.
Fact-specific questions were propounded. Just so we're clear, the fact-specific questions were propounded to people who were taking the survey. Did not, after asking the question even, qualify the false facts as saying this may or may not be true, or this is actually a false fact. The survey didn't tell them that what they might have heard was false.
First of all, I don't call them facts because they're media items. And then second of all, that would be
He's like, facts and the media are not synonymous. The media is like, we don't know her.
ridiculous. And no, I wouldn't do that. So, are you suggesting I follow up? Have you read, seen, or heard if he stopped? And, oh, by the way, if you know that, let me tell you, it's not true.
Exactly. That's exactly what I'm suggesting, because isn't that exactly what happens in the voir dire process?
No.
Absolutely it does.
Your Honor, I'm going to object. Argumentative.
Your Honor, the prosecutor is pointing at my witness, yelling, and his face is turning bright red.
Okay, yeah, you don't get to testify exactly about that,
It's cross-examination, sir.
so I'll sustain you.
Dr. Edelman, have you participated as an attorney in voir dire in Idaho under Idaho laws?
Have I what?
Have you participated as an attorney in voir dire, conducted voir dire in a criminal case in Idaho?
No, I have.
Stephen, yes. Yes. Bill's not done with this. Bill's not done with this question at all. He's like, have you participated in voir dire as a lawyer? Yes. Okay, good. Let me ask it again.
And just to be clear, because in two places, at the beginning and at the end of your testimony, and
Oh no, he is. The witness has an LLM. I don't think he's conducted voir dire, but he's been a jury consultant and he's done voir dire, but he does have an LLM degree. I don't know if he is bar passed.
your
Legal
PowerPoint,
education.
this PowerPoint, you created that, Ms. Taylor. So you adopt what the contents of the PowerPoint states. Oh, thank you.
This PowerPoint. Oh, Judge is living.
Just to be clear,
like we are. This witness is not living. The attorneys are not living.
every
Judge
fact-specific question that your surveyors asked came directly from the probable cause affidavit. Isn't that true?
Well, to be clear, they're not facts, they're media items.
They're representations of
Your Honor,
fact
I'm gonna object.
in the PC affidavit.
Hold on.
I'm objecting and ask that he allow Dr. Edelman to complete his answer before he jumps back in.
They're simple yes or no questions.
What was your question?
Yeah. Let's just say one at a time, okay? Listen to him answer.
The court reporter is going to have kittens. All of you need to slow down. You need to go one at a time. Bill is big mad, but Bill wants to nail Ann Taylor's representation to the court that everything in those questions came from the probable cause affidavit because they did not.
And
he's excited about it. He's ready. He's like,
at some point.
Thank you. So, Dr. Edelman, isn't it true that there are, among the 9 fact-specific questions, that's my characterization of the 9 questions, we know which ones we're talking about. Not all of the representations in those questions came from the probable cause affidavit. Isn't that true?
That is true.
correct.
And are you aware that under Idaho law, probable cause affidavits in criminal cases become open to the public by operation of court rule once person is arrested and appears in court?
I'm sure that's true. I'm just not used to having press conferences to tell the media to disseminate the information far and wide.
Oh, so let's talk about that. That press conference was made prior to Mr. Kohberger's appearance, prior to the release of the affidavit, and the press conference only referred the media to what would be part of the official court record.
Isn't this argumentative at this point? Isn't this argumentative at this point?
Isn't that true?
I don't know. You know, all I heard was this is going to be released. I encourage you to tell your listeners and viewers and anybody who's interested in the truth.
He did say
By going to the court record and looking at the probable cause affidavit. Isn't that true?
I recall you saying, I want you to go to the court record and look at the probable cause affidavit. And what it did was
You're splitting hairs now, doctor. That's fine. I don't have any other questions.
Okay.
Wait, you're done?
So-
Bill, damn
Okay, go
it.
ahead.
What do you mean you're done, Bill? What? Why are you done? He's like, now we're splitting hairs. I'm finished with you.
Thank you.
Yeah, Judge is living.
I want to start with the probable cause affidavit, and I think you testified that that probable cause affidavit was spread far and wide in the media over and over.
And yes, this court hearing is
Do you recall that?
way too long
To
this
be
late.
clear, it wasn't the probable cause
Even late
affidavit
Pacific
that was
time.
spread far and wide. It was details taken from it, put in media stories with editorial comments back and forth in the context of news stories. It wasn't, here's a document from the government that was in the court record. Let me read it to you. That's not how it works.
That is how it works. It can be. That's how we work. That's the first thing we do. Here is this court document. Let's read it. Sir, that's exactly what we do. But he's pointing out the problem with all the not us and like us commentators. That's what we do.
Media coverage. That's how it's reported. Taken out of there. DNA stuff. All the other stuff in there. Reported within the context of a news story.
We did the
So the
whole
news
thing.
takes this document, takes things from it, and runs with it, spins with it, changes it, talks about it, and sends it out.
Yes.
Sometimes, do you think the media gets it wrong after they read something?
I do.
Sorry, what?
Does the media ever get it wrong after they read something?
Yes.
And do those stories have any less prejudice on somebody's, on the reader of that media, whether they're wrong or not.
No, and going back to, I don't care if it's true or not, my focus
That
is
is
to
what you
assess
said.
whether or not media coverage is prejudicial, and whether or not it's led to opinions. It doesn't matter if it's true or not. You don't say, well, I won't test all this prejudicial stuff in the media because it's not true, so I won't include it in the survey, and I'll just assume that it had no impact on people. I find it convenient to be able to disseminate a whole bunch of prejudicial media coverage, saturate the community, and then say, oh, you have no right to test the impact of that information on
He's
the jury.
taking shots
So
at the
it's
prosecutor.
wonderful that you get the benefit of generating all the bias by releasing it to the media and then saying, no, you're constrained defense. You're not allowed to ask questions about it because that stuff's not true.
He's
Or
mad.
you might have told one person in the jury pool a detail they didn't know. Oh, they knew the other 7 details that are highly prejudicial, but it was that one that shifted everything, and that's going to lead to the contamination. Not the thousands of newspaper stories, not the media coverage, not the stuff on social media. It was because a survey vendor called 400 people and asked a question that one person or 2 people in that panel, or whatever it was in that 400, may not have known that one detail. They knew everything else. They're already biased, but it was because they learned that one detail, that's what shifted the scales. That to me is just ridiculous.
He wants to
And
say
if somebody
bullshit.
said, I don't know anything about this case, did you stop?
Yes.
Mr. Thompson was
But how
talking
many
to-
people did you call to get to 400? I'm very, very interested to hear. But what he said is the prosecution doesn't get to go spread this shit all over the jury pool and then not let us ask questions about it.
you about the difference between in the survey between closed questions and what can happen in voir dire.
Yes.
You're not an attorney, is that correct?
Correct.
Well, what's the difference between what you can do in a survey and what you can do in voir dire as far as your expertise?
Bill had asked about that.
Well, again, I sit in jury selections. I've done hundreds of them.
The judge does look less engaged in Ann Taylor's questioning, which is actually starting to annoy me a bit as we watch his face. But we only got to watch his face during Bill's kind of fiery cross and now this kind of rehashing of what we've seen, which is why I would have liked to have seen all the participants for the full hearing, but I'll stop bitching.
I've done research
because
on
it's late.
your transcripts. I've done post-trial
What time is it
interviews
Pacific?
hundreds of times. So I have a pretty good idea of how the process works.
6:30?
In a survey, I can
LA
ask
would
those
never.
case-specific media items.
Like LA would
Well,
never.
someone says, I just recall what was in the newspaper to the open. I can ask a follow-up. Have you read or heard if David Nichols was convicted by a jury for murder? Could never do that in a voir dire because you'd be poisoning a well, just like in the John Fight case. I rarely see during voir dire somebody admits comments on something like, oh, I read this, and then there's a whole discussion and explaining to everybody, well, that's not really true. That fact was just in social media. It's wrong. That is not a normal common thing that I've seen in voir dire.
In your experience, 15 years, you said, doing this work, have you had a situation where you've been stopped midway through your process?
No.
What do you care about?
What's what?
What do you care about? I've heard you say
Oh, she's
that
worried that
whether
might
what
have
the media sends
annoyed the
out there,
judge.
whether all of those things are actually true or whether it's a spin off other information, that's not what's important to you. What do you care about in your work?
What I'm interested in is assessing if there's prejudicial media coverage. Inadmissible prejudicial media coverage is some of the most concerning. Misinformation
Or
is
what's
some
for
of the
dinner.
most concerning. What I care about is what extent of that stuff has permeated the jury pool. What do people know? And do those specific details generate bias, prejudgment? Again, I just, the idea that there can be all this stuff out in the public that's misinformation, prejudicial, that benefits one side, and you're not allowed to ask if people know that detail because you might taint one person who already knows a whole bunch of information. But that, again, like knowing the detail about the stalking comment. Okay, that person knows all this stuff, but that's the thing that's going to change everything. And now that person's poisoned because they heard it in a survey. But the fact that There's thousands of newspaper articles and television stories and comments on social media. 80% of people in this community talked about this case according to the survey. None of that matters. It's because I did a survey and asked that question. I mean, that's just, I don't even know what to say.
He's like, that's bullshit. It's preposterous. But look at Judge's face looking at this witness.
Still want to finish the surveys if we're allowed to do them right?
I'm sorry?
Will you still do the
He's like, I don't
surveys
know
if we're
about that.
allowed to do them right?
Yes, if we're doing them correctly, I'm open to continuing. Now, I think this whole thing has created quite a whole new narrative that it's almost wrong that the defense is doing something inappropriate by doing the same standard survey that's been done hundreds of times in other cases, including in Idaho. So I don't know how people will respond because of all of this and what it's generated, but I would certainly try if we're doing the survey correctly.
Thank you. I don't have any questions.
Okay. So one thing I just want to sort of clear up because it's come up.
Judge has questions.
Back and forth with the.
And again, the judge sits in the corner of the courtroom. So when he's looking that direction, he and the witness are looking at each other. The kind of the wood end of the bench is near the witness stand. That's Judge's bench because he's right in the corner, which is odd.
Questions that aren't true. Okay, and those were not in the probable cause affidavit. And so I think it does have some bearing on the non-dissemination order because our whole purpose, okay, both counsel were trying to protect these things from coming out to the public or to the media. That's, I think, one of the key issue.
He wants to talk it out. Judge wants to talk it out.
These particular statements, so there were two questions right at the end. And the ethics, okay, of the lawyers, basically this non-dissemination order is really a mirror of the ethics in Idaho, especially for the lawyers who are participating in a case like this. And one of the things that is permissive.
Do you have a question, Judge? Or just
putting this information out to the public is information contained in the public record. Okay, so the public record is a case file that is available to the public.
He disagrees.
That's the law.
Look at his face.
And
Look at the expert's face. The expert does not agree at all. Look at it. He's like, nope. Negative, Ghost Rider. He believes, I think, based on this response, that the public record is what is in the public, not what is in the unsealed public court record, because there's things in the media that never came from the court record, but you have to know if the jurors know.
Lawyers, basically, this non-dissemination order is really a mirror of the ethics in Idaho, especially for the lawyers who are participating in a case like this. And one of the things that is permissive for putting this information out to the public is information contained in the public record.
And I backed that up because I wanted to hear him say it again.
The public record is a case file that is available to the public. That's the law. And so to then say, well, we have these other issues, okay, of concern that have been spread through the media, hundreds and hundreds and hundreds, as you've said, that we need to test that. But then it is a tightrope to balance this. So I'm just not accusing anybody. I'm just saying this is one of the things that's pushed or pulled both sides apart and puts me in a very difficult situation. Okay, trying to make that fair for everybody.
And I
Okay,
think the witness is trying to say it's not a difficult situation. This is how we do it in cases. And the prosecution is saying this is difficult. You're disseminating information that's not true.
so that's what that's about. I'm not asking you to answer
Are you just
anything.
having a?
I'm just trying to think about a solution.
Are you just having
I
a
don't know if there
chat?
is a solution. Okay, it's out there. But it does have some bearing on additional surveys. And what you're saying is, if you can't use this, apply the surveys that you want to complete, that you need the same questions.
Right.
Otherwise, it's not legitimate.
Well, let me ask you this.
Okay, so if you have an answer to that, that's.
Let me ask you this one. So if you said you can ask certain case, like media items, like the other 7, for example, that they come from the record. That's a possibility because you can still measure what we're talking about. The specific knowledge when you ask these questions is high. The more you know, the more likely are to be prejudiced and biased. And you see differences in the A account or a different count. Now you have to acknowledge there's these other stuff out there that's highly prejudicial. And we will not know if the rate of the awareness of those details are as significant as they are here. So then it's an unknown. So if the argument is, well, it doesn't look so bad because all I know are the things in the affidavit, for example.
It's because we didn't ask the others.
There's this unknown out there again, because those items happen to be one of some of the more prejudicial items that we found.
Yeah, this is a death penalty case. And so when we're talking to jurors, we're going to probably talk to a lot of jurors individually.
Sure.
Right.
And it's going to be on the record. And we're going to talk about them, about what they think or what they've heard in real detail. So there's that. Okay. So
Solo
I
warrior.
I guess I'm kind of wondering too, in terms of all the people that may have been called that didn't pick up the phone.
Yeah, we want to know
don't
that. Too.
want to pick up the phone because everybody knows, okay,
We wanna know that
I
too.
don't know this person as my phone is ringing.
Yeah.
And I'm not, and then there are lots of people, including me, that would never answer a question, okay, on the phone. So how do you deal with that? How do you balance that? There could be
Judge is now just us. It's like, sir, so I know you didn't bring it up and none of the lawyers asked, but I'm like, you're here and I'm just wondering. So can we just circle back? Because I want to have a chat now. Judge is like, now I'm fascinated. Can you just answer questions? Because I'm the judge.
400 people out there in Latah County that say, I don't want to say anything about this.
Yeah.
How do you factor that?
Well, so you have 2 things. So I was unpacking both of those. So the jury selection question, like I'm sure you've done a million of these. I've done quite a bit. I've done a lot of high profile. And from my experience, asking people in the general case, like a DUI, what do you think about DUI? And they tell you generally I'm against it. That doesn't, I have a big issue with that, whatever. That doesn't mean they can't be jurors because it's a general attitude. It's nothing case specific. And there's hundreds of studies that show general attitudes are much less predictive than specific attitudes. This is different and unique because we're talking about attitudes and beliefs specific towards this case. That's a whole different animal. And that's the unique nature of high profile cases. So when you talk to people individually, you still have the memory issue. You still have the recall issue. Like you will not elicit everything that you're doing. It's just memory does not work. It doesn't matter if they're under oath, private. There's so much research on it. Our brains don't change just because we're under oath. They work the way they work. Your other question goes to
the witness, by the way, it's easier to tell, but his tone of voice seems incredibly less defensive, much more engaged and curious, and much more excited about, like, let me tell you about how we do our work, which is nice to be able to see now that we can see the shift in the demeanor because now we can see the court.
Response bias. Like, what's the response rate? Is there something unique about people you miss and so on? So there's a lot of work on that. And one of the things we do is why we collect like demographic information is to see, are we missing groups? Are we overrepresenting one group or the other? is there a relationship between that factor and bias? And there's a lot of research on response rates, and what it finds is surveys that have high response rates, where like everybody takes their survey, and surveys that have low response rates, where it's like less than 10%, and you compare them with public opinion polling and so on, politics, there's no difference. You find in most instances, the results are the same in surveys. So high response rates are not necessarily correlated with more reliable, valid survey findings. And that's something they've done a lot of work on, because survey rates or response rates have gone down quite a bit. I think
Yeah, caller ID has made it so we don't have to answer the phone. I'm not surprised that Emily, I'm not surprised that response rates have gone down.
Yes, so it could be that you're just getting people who like to talk on the phone. Sure. With strange.
Is Judge saying you could just be getting people who like to talk on the phone? Like, are you just curious, Your Honor?
Yeah, and from this case, I think people are so invested in it, like a lot of unique things. So people, talking about what's happening, they're very invested in this case. It's unique. In small community, it's not surprising. But just what I'm finding, there's so much prejudgment, detail, and so on. I don't think I think it's fairly representative of what you're going to see. Almost everybody in this jury pool knew about the case, like comparable to like the George Floyd case. The bias was the same in terms of comparing it, not to Chauvin, who was George Floyd, but Alexander King, who was another officer on the scene. Like the rates are similar to that. So that was another high-profile case that was a lot of tension and stress, so on. And we still got very meaningful data. And we've done so many times. Like you kind of understand, like response rates are going to be lower, but there's nothing to indicate that, for example, we're missing an important group. And
right,
if we were, we would wait
the work can work if you let us just do our job.
So,
is what he's saying.
So in Utah County, it was about 1% of the population.
Yeah.
So hypothetically, if we say, one of these counties that are interested in data, which is obvious.
Yeah.
For other reasons too. But would it be 1% of the population in Boise? No. So okay, so that's I was kind of wondering about that. We have to talk about 2,000 people. Okay.
So how that?
Yeah. Go ahead.
Yeah. So it's a great question. So you can take a small sample and generalize to the population if it's done correct. So like if you look at surveys of the United States, the sample sizes are similar to what we did here. Maybe it's 1,000. And now you're generalizing to every city, county, and so on across the country. Everybody has a known probability of being selected. How you pick your sample size, it's called power analysis. So how you see polls of like, you'll see a number like 90%, and they say plus or minus 5%. So it's either 85 to 95%. Basically, it's plus or minus 5%. That's kind of industry standard. And you take a conservative approach. So let's say you ask a yes or no question. You would say 50% would say yes, and 50% would say no. So that's a lot of variance. So that's the worst case scenario. How many people do you need to talk to? So if that happens, your confidence interval is plus or minus 5%. So,
he's trying to work backwards to how many people you would need to ask in
if you did
Boise.
Ada County, it would be 400, and your confidence interval would be the same as it is here with a smaller anyway. So as long as it is using the general concept of a randomized sample, you can generalize that population with this.
So if I kind of interpreted this, one of your answers just a moment ago about the getting rid of the questions that are false, okay, that just came from the media that did not come from the public. From the public, but
he wants to get to he's trying to ask, what if we get just, my brain has stopped. I realize that they are on Pacific Standard Time, but it is still unusually late for court. But he's trying to get to, can you just get rid of the questions that aren't coming from the court documents and still get valid data?
Legal part. Could you go ahead with that and have legitimate data?
Findings.
So I think you have the 9 questions. So if you look at it,
He's
are the
answered that
other ones
already.
okay? Are you telling me there's 2 that you would like to exclude and keep the other 7?
Stalking social media.
Well, maybe. I haven't made a decision, but I'm just wondering if,
Hypothetically, sir.
I mean, at first in your testimony, you said, well, I can't do it without doing the same questions. That's one of the problems, okay? The part of this argument. I mean, if maybe it can be done without sort of sending information out there that is false, that might, affect people.
And the witness doesn't
looking into that.
The witness doesn't see it as sending information out there, because he found the information because it was out there, which is where I think you can see his face being like, are we still not understanding that I did not send anything out there, that the information is out there and I am asking about it?
They're thinking that it is, they believe in it, even though they shouldn't. Is that something that can be done?
Well, if you do it that way, there are potential compounds and things that will arise. And again, the thing I struggle with, and I understand the public record dissemination, so we've done this before. The thing I get to is like, we're not really disseminating it. We're asking if people know about detail that has been disseminated through the megaphone of the media. So I'm really trying to just track what people know. I'm not trying to pass on information through a megaphone. So checking out 400 people that are talking to.
He's saying he's not trying to
500,000 or something.
Right.
Counting
This guy's getting grumbly.
the risks and benefits of doing it that way. It seems like there's a very low risk of undermining or contaminating the jury pool when you're doing that, versus the risk of getting a huge black hole of, well, we don't know what percentage know this highly prejudicial detail. Like, what are the odds, or like what impact is doing a survey going to have on the jury and the community relative to the media coverage that's already out there? So
Do you ever put a caveat on the beginning of the questions where you say, well,
No,
we want you to understand
no.
as we go through these questions that we're not determining guilt or innocence. We're not determining.
He's not going to put a caveat on it because he's trying to ask them if they've determined, based on the things they've heard, guilt or innocence. He's not going to put a caveat on it. People are going to be like, why am I talking to you? Goodbye. Yikes.
False or true. We just are interested in your answer to our questions, and we want to be careful that we're not sending out something that you.
Every time Judge says sending out this expert, looks like he wants to die inside.
And there's no right or wrong answers to any of your questions. You could always say no opinion or I don't know to any question. It's going to remain anonymous. We're just interested in your views. And so there's an introduction to that section with those 9 items. Usually it says you may have, we're going to go through some items in the media. You may have already reported some of these already, but we're interested in what you've seen or heard. We can add a caveat to that. Like, some of these may not be true, if that addresses it.
Oh, well, there you go. I'm surprised by that answer.
Not all these media items are factually accurate.
Sure. People pick up the phone for somebody and they think, somebody with authority maybe, and they think, oh, well, this is really kind of the beginning of the trial.
The thing that's hard is Latah County's already been questioned. So all of this is too late for Latah County.
Something. I mean, people misunderstand all kinds of things out there, right? So
you can certainly tweak the intro. Now, we don't just jump into it. We don't say we're an authority. It's usually.
No, I know you don't say that. I just say,
Yeah. So we can work on the introduction if that would address some of those concerns so that people understand. Not everything in the media is accurate. But the thing is, like, we
can remind people that not everything in the media is accurate.
If we're going to say, for example, not everything in the media is true, they get a lot of things wrong. You would not want to say that before you do the prejudgment portion. You can do that after. when you do the case specific items, because what I want to know is what are people's opinions about guilt or innocence. I don't want to give them instructions and then get socially desirable response in a survey.
But you don't sort of measure it, this person as their bias until you get into the specific questions, specific stuff, because otherwise it's just
I think
yes or no, and you can't determine bias just from that.
I think he's trying to measure how much people know and if those people tend to lean towards believing Kohberger is guilty or not, but I'm not the expert.
Yeah, so the prejudgment question comes before the case specific media item.
Right.
Because then you would ask, if I read those 9 items and then I said, okay, do you think he's guilty? I just told you all this stuff.
He just
No.
said that earlier in his
So
testimony.
the question is, do you know about the case? And then it's based off of what you've read, seen, or heard about this case.
Do you have an opinion?
So-and-so is guilty of murder, whatever the crime is charged. And it's on a scale. Yes, definitely guilty. Yes, probably guilty. I know, probably not guilty to murder. Based off of what they've already been exposed to without you giving them anything. So they have no information.
That's
beyond what
asked
they've seen in
first.
their home. And then you ask open-ended questions like, what do you know about the case? And then other things. And then you get to those case-specific media items.
And that's when you can theoretically measure bias.
Yeah, well, I mean, I correlate those recognition items with the prejudgment questions earlier, right?
The more you
It
know, the
doesn't
more you think he's
necessarily
guilty.
be causation.
Yeah. Well, they're chi-squares. You can do different things. You can do linear regression, whatever you want.
Please don't talk about things being squared to me. Sir, I'm a lawyer. I do not math. If we start getting into statistical probabilities and squaring numbers, it's long.
But what I want to know is people who report later on, they know that detail, did they report stronger views of guilt? So like, I'll give you an example, like
Correlation I can rock
if
with.
you only knew 2 of those items, prejudgment was only 20%. So if you only knew 2 of the 9 items, most people had no opinion. Versus if you knew 7 or more of those items, it jumps up to 82%. So that's telling you, like, the more facts you know, the more case knowledge you have, the stronger your opinion is.
The more
Right? And that's what you see in literature. That's what you'd expect to see.
I wonder what Bryan Kohberger thinks sitting there over and over again. Well, this expert hired by the defense team says the more people know about this case, the more they think he's guilty. I just wonder if that is lost in all of this conversation or if that is ringing clear.
If somebody was being told, oh, that was just all false information, would that bring down the bias?
In what?
Measure? But you were saying earlier that it kind of pessimistic, I think, maybe that maybe absolutely
Apologies
correct,
for the
that once
yawning.
people
It's
have an
9 o'clock.
opinion, they're not going to let go of it, even if they get the truth.
Yes, yes. It's called belief persistence. There's a bunch of research on that.
That's kind of going around
Yeah.
political
And we see it.
things right now.
Yeah, like if you talk about, everybody has an opinion of Donald Trump, so.
I'm not going to say.
Yeah, I know, but if you,
Neither are you.
so.
All right, so
The law nerds,
for
so the law
that.
nerds prefer pop culture references.
Any questions online, Ms. Taylor?
Your Honor, I don't have any other questions for Dr. Edelman, and we do have a summary for the court at the appropriate time.
Okay. Mr. Thompson, anything online? Okay.
Sir, thank you.
So go ahead, Ms. Taylor.
Ms. Manslock is going
Oh,
to
you
give her
know what?
summation.
Okay.
Let him get off the stand.
1 second. I'm ignoring the court reporter, and I'm just so immense in this that I need to fully maybe rest. Are you okay?
Yes.
Okay.
The court reporter's like, you could have ordered pizza, you didn't. Can we just be done, please?
Okay. Well,
I guess he's been excused off the stand because he just
thank you, Dr. Edelman.
left.
Appreciate your testimony there. So, are you okay? Yeah. Okay, great. Okay, let's go ahead.
Thank
No.
you, Judge. I realize it's late in the day, and I will tell you that this takes about 9 minutes for me to sum this up.
Who are
But I
you?
do want to talk about something in advance because you're asking questions of our expert about his process and changing the process that is impacted in the United States Supreme Court law. And the United States.
Can you please identify yourself for the call, ma'am? We're not. Could you or identify yourself for the record? Because I don't we don't know who you are yet.
Supreme Court law requires that part of the analysis for the court on presumed prejudice
One of the defense
include
attorneys?
false media coverage. It's not enough for it to be all truthful media coverage. So before you...
This is the standard they have to meet for the change of venue motion. So she's saying the court has laid out what we have to meet, and this is the process to get there.
Start suggesting that an expert change his methodology that's accepted practice. It's really important that you go back and look at Skilling and Haddon and the lineage of cases that get us to venue and what the court has to decide in determining presumption. The question you asked, the answer today is, where do we go from here in the survey process? I want to answer that question in two parts by summarizing what we can do and what we can't do. We can and we need to finish the process that the defense undertook. It was completely valid. It was standard in cases like this. Dr. Edelman is an expert in this field, and he has done this jury research and this work for 15 years. Nothing about the format, the methodology, the questions, or the fact of the survey itself was wrong. You've talked about two questions that you are describing as false because they're not in the affidavit. But if you look at that affidavit and what the...
Because they're not in the court record?
The media has done with those things is they have created a narrative based on the facts that are represented.
And the fuckery? They took the facts and made them into fuckery?
In the affidavit. Now, I would agree that there's a lot of information in that affidavit that is just flat not true. But if we focus on where we are right now.
That's for a different day.
There are representations in the affidavit about multiple trips to Moscow from Pullman and a return trip to Moscow from Pullman in the morning that lead a reader to the word of stalking, that you have a problem with that word being included. Reflect back on the case law in the United States Supreme Court about showing false information, but also look at that affidavit and the way the media has construed that in its representations, in its reporting that is so prejudicial. Because the basis for this spin, the foundation is right there in what you are describing as the public record. Now,
she's like, Your Honor, the PCA is out there, and then the media speculated wildly. So what do you want us to do?
I fundamentally disagree that the only public record in this case is what's
I think Judge is holding a yawn at
on
this
the
point.
12-page docket. The public record in this case that the entire nation, the world, and looking at, and especially Latah County, is derived and construed out of that public record.
So can I ask you a question about that? This public record thing is really kind of circling around, because what's the purpose then of the non-dissemination order? If everything out there in the
public record
is the public record.
Well, my understanding, Your Honor, is that it's one of the primary issues was the credibility of the person that is out there speaking. We did not want law enforcement, 159 officers out there talking about police reports and disseminating that. We didn't want the prosecutor doing press conferences like we saw on 12/30/2022. We didn't want the defense getting up and doing press conferences based on the information, because we have information that no one else has, and we are consulting with experts that the public doesn't know about. And so we have a level of credibility that the others
which
don't
is what
have.
The order says.
And so that is my understanding of what we're trying to get a hold of. And it's been pretty effective in this case until this valid survey that happens in high profile cases has been construed to be something nefarious, which it absolutely is not. As you've heard, It's been used in Boston bombing, the Parkland shooting, the Colorado theater, George Floyd, hundreds of cases going back decades. Dr. Edelman's declaration and now his testimony are uncontroverted evidence before this court on this issue. It's the actual evidence that the court, and finally today, you're getting informed about the validity and the science behind the process.
I mean, most of it was in your filing.
Nothing that was done is worth the hysteria and the hyperbole that keeps getting expressed in this courtroom. The questions asked.
She's like, Ann Taylor might not be big mad at Santa, but I am big mad at Santa. The hysteria and hyperbole. These cases this week, oh my God, between the prosecutor calling Baldwin's or referring to Baldwin's ego as impressive and the hysteria and hyperbole, it's like too late for this, but okay.
The topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see. And the research methods used to determine what was out there,
the nastiness,
is the traditional way and the scientific method that experts in this field use, just as Dr. Edelman testified.
Your Honor, we have receipts, timeline, screenshots, fucking everything. Sorry.
And to be sure, the purpose of this is to give you information.
I couldn't help myself.
So that you can make an informed decision about venue. It's not for a nefarious purpose. It's to arm you with facts and information so that you can apply the United States Supreme cases that have been adopted in Idaho and determine whether or not there's presumed prejudice. You know, when we first started talking about whether or not there was going to be this venue hearing sooner rather than later, Ms. Beatty for the state said at least 3 times, Judge, they can't just come in here with affidavits. This case law says that they have to have more. The more that we are gathering to provide you, at least part of it, is this survey. In terms of the proposition that this survey taints the jury pool, first of all, you heard from Dr. Edelman that if someone answers they don't know, a second question tapping into that is asked and the process stops. There's no other questions other than demographics because they don't want to poison anybody who doesn't know. So for there to be this.
I'm getting a little punchy because it's late, but Scotty doesn't know. Scotty doesn't know. Scotty doesn't know. Don't tell Scotty. I think we just need to play it in court. I think we need to play it in court because she's saying, look, Scotty doesn't know. So that's where we're at in this case is, hey, Your Honor, if somebody doesn't know about the case, we stop and we don't ask them. But if somebody knows about the couple questions, they definitely get to the stalking one.
Proposition that all of these questions, these 9 questions that are later on in the process were put out there intentionally to poison the jury pool. That's just flat false. And the other point is you can't taint what's tainted. When you hear what the statistics are, as it relates to this county, 97% of the people had familiarity with the case. 79% of the people knew 5 or more prejudicial and false media reports. 81% of those who had heard about the stalking had determined and took a position that Mr. Kohberger is guilty. These people that were surveyed didn't form.
Well, it is a really prejudicial fact. And yes, Chad, I see you. You can't taint what's tainted. You can't insert the taint. We know it's coming.
The opinion when they were being surveyed. And they didn't then go research their already strongly held opinion because of the survey. These are deeply held opinions in this community within this jury pool. The Latah County citizens have accepted the information placed before them by state actors. It's not just Mr. Thompson that did a media report and talked about the probable cause affidavit. Chief Fry, the coroner Kathy Mabbitt. We've got search warrants from Pennsylvania out there in the public record. We've got hundreds of search warrants in the public record out there.
And that defense attorney from Pennsylvania as well. Can we talk about that?
From Idaho, we've got all kinds of pleadings. This is all information that's put out into the media. And having the state now claim this moral high ground is an oxymoron.
Your Honor, they started it.
It's a complete oxymoron for state actors to put this information out in the public and now say, hey, wait,
I'm waiting for her to just call them by their government
if people
name.
have believed the information that we put out there, you can't do that. That harms Mr. Kohberger. We as a defense team have the obligation and frankly the privilege of defending Mr. Kohberger and defending his right to a fair trial. And in doing so, in arguing that venue should be changed, we have to show you that there is presumed prejudice in this community.
That's true.
And since we have the burden of this, and you now know essentially from this expert that there is presumed prejudice in Latah County, you have to ask yourself.
He's like, I'm not done yet, but I presume there's prejudice. Like that is the result we're going to get to.
Do you want more information to know where the better venue is? And that takes me to the next point, which is what we cannot do. You've heard Dr. Edelman say that it goes outside of his standard of practice and the scientific method that has been used for decades, that has been used in hundreds of cases to take your ideas about what should be in questions, to take the state's ideas about what's being in questions, should be in questions in the survey. He follows a process. That's the process that he needs to follow because he has to provide the court with apples to apples comparison. Another issue that has was addressed last week that I want to touch upon, and there are two, is this concept that if we just done a juror questionnaire, it would have addressed all of that. At the stage that we're at now, which is setting ourselves up for and preparing for a venue hearing, we have to justify a venue change. The standard that you're going to be looking at, according to the Supreme Court, is whether or not a presumption exists where the record demonstrates that the community is saturated with prejudicial, false, and inflammatory media publicity about the crime. The case law mentions
definitely
false
not 9 minutes.
Media publicity about the crime. That's what the survey assesses now. Another way to determine actual prejudice is a questionnaire, and that is done prior to selecting the jury. And at that time, we are looking for actual individual bias of the prospective
But that
juror.
can also be the
methods
basis for those
different stages of the
hearings.
case. And right now, the proper method is a survey. Another solution that...
So basically, Your Honor, this is all your fault. The prosecution argued that it was premature to do these motions because the trial date hasn't been set, and the trial date is probably going to be more than a year out at this point because we're looking at summer 2025. So when the prosecution said it's too early to do all of this, you said, no, let's see what happens. They're saying the survey that would go out from the court, it's too early to do that. So really the court created this problem because there's no other way they can attack the problem because it's too early.
You mentioned last Thursday was simply to strike 400 people surveyed from the veneer. And I want to talk about that. First of all, that doesn't address the problem that's very clear that we have in Latah County. And so if you extrapolate the percentage of people that have drawn a conclusion about Mr. Kohberger's guilt.
Like Judge
You
wanted more
extrapolate
info.
that to the
Here it
county
is.
with numbers like 81% have concluded, if they are familiar with the media information about stalking. There's no prospective jurors in this county. You mentioned, this is 1%, but there's much more analysis to what the prospective jury pool is here. First of all, the jury commissioner, I think you talked about her when we were talking about whether or not jury trial was going to be, speedy trial was going to be waived. You said, I think it had expanded the pool to 1,000. Am I right about that number?
What?
I can't remember. It was maybe more.
Okay. So if you extrapolate the numbers that we know of prejudice exists, I mean, that leaves us with a very small jury pool for trying to do voir dire in a death penalty case. But if you look at the population as a whole, what the U.S. Census says about Latah County is that almost 18% of the population here is under the age of 18. Almost 18% of the population here is over the age of 65. That eliminates, close to 35% of the population that's even eligible to be in your jury pool. Second, and more importantly, I can't find statutory and legal authority for you to strike 400 people out of the veneer up front. I found the opposite. As you know, the clerk or the jury commissioner pulls from the jury pool that's approved by Idaho Code. And this is a really important section in Idaho Code 2-202.
She's like, actually, you can't do that.
It is the policy of this state that all persons selected for jury service be selected at random from a fair cross-section of the population, and that all qualified citizens have the opportunity to be considered for jury service.
Rest assured, I was just being sarcastic.
Okay. Well, I took your sarcasm to heart, I guess, last week.
I apologize.
Because it was a very...
I didn't think he was being sarcastic. When Santa was like, I don't know what we're going to do, strike all 400. And he's like, yeah, we'll strike all 400. I didn't think he was being sarcastic at all. I thought he was like, no, that's the solution. We'll strike all 400. I read it the exact same way she read it.
Serious day, right?
Every day is very serious.
Right, but last Thursday was in particularly a tough one. I think we can all agree.
There's going to be more tough ones ahead, I'm sure.
For sure. And we all need to give each other grace.
And it's going to take us another year and a half to get to trial if Judge wants to have 7 hearings to make a ruling.
Thank you.
I will end by saying this. Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence.
Okay.
And right now he's being held to have a trial in a county that believes that he is guilty. In this country, we pride ourselves on a jury system that doesn't stand for that.
Ma'am, if you mention the Magna Carta, I'm going to throw something.
In this moment, I see that you have 2 choices. You can let us continue and do comparative surveys as planned.
Or we'll take you up on an immediate writ and you will get wrecked. Chances she says that? 0.
Or you can maintain the stay. And at the venue motion, you will hear that the data for Latah County shows a presumption of prejudice. But you will not have comparative surveys to fully inform the court. As you consider this, there is absolutely nothing that gets risked if you change venue. But if you deny a change of venue, Mr. Kohberger's constitutional right to a fair trial is denied. There's only one human being in this case with a right to a fair trial. It's Mr. Kohberger's and his alone.
Ma'am, we're aware.
There's no legal right of this community to have a jury trial here. Thank you.
Thank you. Mr. Johnson?
Thank you, Judge.
Rob, you can't leave. This feisty hearing is not done. I mean, I think in real time it probably is because we are catching up, but it is not done. It is not done.
Let me bring this back into perspective. Our motion deals with the court's non-dissemination order. It was agreed to by the defense. In fact, the idea of the non-dissemination order was initiated by the defense
most
their
of it?
February 30th, 2022 motion for a non-dissemination order to prevent extrajudicial statements. That would be statements outside of the public record, which is the court record, that have a substantial likelihood of heightening public condemnation of the accused. And the state's position is that the fact-specific questions, and I understand from Dr. Edelman why the questions were asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case.
From the lawyers or their agents.
Facts that include those that are not true, acknowledged from the stand that they are not true. Which, interestingly enough, I look at the PowerPoint and slide 15, which talks about the American Society of Trial Consultants.
Is that the one that you're on? I want to know how you feel about that.
Professional Code on Venue Survey
I don't think we're
says
going to get to know.
false facts should generally not be used to test accuracy of other responses in venue surveys. So
But I don't think it was being arguendo. I don't think it was being used to test other answers. I think it was being used to test knowledge.
false facts are used, they must be clearly false. There's no possibility that the respondents who know about the case use false facts with true facts that have been publicized. We have an inconsistency there, which frankly is logical. It makes sense. And the state is coming from a position of being practical and trying to use common sense here. As I listen to what we have heard today, and in part from last week, it seems that the position of the defense is it is okay to risk tainting additional jurors in order to ascertain bias of other potential jurors.
Yes. Or
And I'm not sure that's
or you can't taint what's already tainted.
the way this court should do business. If we accept what the defense is suggesting at this point, and again, we are not arguing venue today, and so I'm not going to try to get into all these numbers and all those sorts of things. We'll save those for another day. But if we were to accept that we have perhaps on one issue 20% of the jury pool.
Bill, you're me. We're not gonna XYZ immediately proceeds to XYZ. We're not gonna get into numbers. 22%. Bill, don't be me. I do it all the time, sir.
Statistically available, well, that's more than enough people to select a jury from. So it's not nearly as overwhelmingly compelling as I think is being suggested here.
Well, that's the adversarial process, sir. That's how that works.
I want to be clear again. Ms. Manslock used the word nefarious several times, suggesting the defense was, or that the state was accusing the defense of being nefarious. And sure not, Your Honor. I am not suggesting that there was any ill will or motive by anybody over here. What we are suggesting and what we believe that the record shows is that this court issued a specific order prohibiting the dissemination of specific types of information, including the identity or nature of evidence expected to be presented, including the performance results of the examination or test. There's no question that those 9 questions included violations of the court's no contact order. That's what we're here about. And apparently there was some miscommunication or misunderstanding about the integrity or the importance of the non-dissemination
no one
order.
can agree.
It sounds like today that maybe because these types of surveys are common nationwide, then the non-dissemination order really doesn't matter, which is a little disconcerting, but I don't care about what happens anywhere else. All I care about is what happens in Latah County, in this court. It's far above my pay grade to go and analyze what happens in a big city or some other part of the country.
New York City. It's such a prosecutor thing to say, Your Honor. The rest of this is above my pay grade. But this community, because he is a prosecutor for Latah County, he's like, this community is my community. This community is the community I prosecute on behalf of. And this community was impacted by this crime. So he's offended on their behalf, and he probably likes the jury pool there better than other counties. So he's going to fight to keep it in Latah. It's also, it can be quite burdensome, not just on witnesses, but victims' families and the impacted community to be elsewhere. And the defense is like, yeah, not our problem. Our problem is this defendant sitting here in a death penalty case. So that's our problem. So he's going to do his job. She's going to do her job, but he's trying to ground it back down. I don't like that Judge seems to tune out the defense a bit more than the prosecution. I think we could see it more in this hearing than in some of the others. But this is also the jurisdiction where this judge sits. So, like, I get where they're coming from, but also if they can't get a fair jury here, then you don't want to do this case twice.
I know Latah County. That's
Right.
where my interests are. That's where our interests are here.
That's where the impacted community is.
On the issue of whether the survey can be changed, I think that does present some challenges based on what we've heard here today. But the solution for that is very easy. We just back up, and if the defense wants to pursue the survey, they do a new survey with a new group of people and take out the objectionable questions. And then once they've done that, they can proceed to do that identical survey in other veneers around the state, whichever ones they want to select. And that would be the proper way to do this. Now, we may hear, oh my goodness, that's going to consume time.
I thought we weren't talking about that down the road. I thought we were just focusing on the non-dissemination order and what we do next. Like, aren't we? There's a stream tomorrow, sir. I know you're on Pacific time or whatever, but like, oof. But the point I thought we were trying to decide, and the conversation keeps expanding, is did this survey violate the non-dissemination order, and can it go forward in other counties? And we are like, oh, we have gone off to the races in other directions. And I get that everybody wants their chance to respond. I do that too. I'm just also tired.
That's going to consume a lot of money. Well, I'll tell you right now, I don't care. If it can't be done right, or if that's what it takes to do it right, then we need to do it. This is a big case.
It's like, whatever it takes.
And the finger for this cannot be pointed at anybody but the defense. I'm not suggesting an evil intent, but the practical effect of the decisions made on behalf of the defense was to ask these questions and to create a situation that we've been having to deal with now for 2 hearings over the past week, well into the evening on a Wednesday.
Santa, you said evil intent.
That's the way forward, Judge.
Okay.
Thanks.
Thank you. Oh.
Go ahead.
We're
Judge,
not,
I'm just gonna end really quickly with this. We didn't violate the non-dissemination order. You know, the information that now he's calling facts, you know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information, the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those 2 questions were not in the public record.
we have a fundamental disagreement about what the public record means.
They were. I mean, they came out, but that was not the
And he's stuck on that.
court.
That's not the court record.
I mean, where it came from. It just came out of the media or somewhere.
The ether.
Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client.
There isn't.
So
People
I mean,
extrapolated?
here we are. I mean,
Speculated?
that happened. kind of unfortunate. I totally understand the,
But if it happened and if it creates bias, then don't they get to ask about it? Like, I understand why the prosecution is like, what is happening with these questions? But if it's out, and it seems like everybody's agreed that it is, then you can't really ignore that it's out, can you? I don't think that's going to work.
the reason to have false information out there, but I mean, I have to just want to clear that up. The other questions, that's all from the public record. I have a question.
Mm-hmm.
Anybody tell, if you can find somewhere in the public,
It's not.
public record.
It's
that
not.
Those, claims were made.
It's
I'd
not.
like to
It's
see
not. We went through the entire public record. It's
I think
not. It's
both
internet
sides
speculation.
are looking at a different definition of what public record is.
Yes, they are.
I
Clearly.
have looked it up. It's the public record from the case. So that aside,
I think he's reiterating that it depends on what the definition of is when it comes to the public record. I think his definition of public record is the public court record, not things which the public is discussing.
appreciate
But we're just like
testimony, the
circling.
arguments on both sides. I think it's a challenging issue. It's something that I'm going to have to
not rule on today.
struggle through,
Yeah.
figure out what to do.
I mean, we knew that was coming. But are they going to get to continue their work or not? He's not going to decide. So the defense has got Ann Taylor's face looks like she is pursing her lips as hard as she can to not say, we have been paused. We are on pause longer than like Dorinda at this point. So can you take us off of pause and tell us what we can do? Because at this point, Judge is like, I'm going to need to noodle, which I get. I am a noodler. I need to noodle on what to do about things. I need to noodle on information. I understand. He needs to think about it. The problem is they are still on pause while he thinks about it, which it makes me frustrated for the defense and their expert going, oh my God, you were supposed to make a decision. We are hours into a court hearing and no decision has been made or is going to be made tonight. So what are they supposed to do then? And this is going to bump out when they can do the motion for change of venue.
And I understand that there's some urgency to get that out, so I'll do my best.
She wants to focus on other shit. She's like, can we please move past this part of the trial so we can do other parts of the trial?
So, anything else we need to talk about?
Yeah, but what are you going to do next? What's next? What?
Your Honor, just the logistics of the court's decision is yet to come. We can't continue the surveys. And we've got deadlines next week, midweek for briefing and the motion for change of venue for May. So I'm wondering if we want to consider resetting that motion and that deadline now. I still want to keep the hearing on May 14th. We have a motion to compel already filed to be heard that day. So we could still use reserved court time to make some further advances in the case. But I'm concerned about being properly prepared for the change of venue, waiting for the decision,
Fair.
especially if we're allowed to continue with work.
And you should be.
And I told you last week that I would give you more time. I won't be fair about it.
Judge likes a lot of hearings, which is going to be difficult when we get to trial. Like there are times I just love his fascination with things, but the hearing, how many hearings did we do on whether or not the standard for the grand jury was correct? Because he was delighted by having those conversations. But it will start to wear on everyone if this trial is already estimated to be 3 to 4 months. But if he needs more time, it's going to be tough. His His job is to not suss out other information. His job is to rule on the information. Both sides argued yes, no. Like that's you are the referee, sir.
So you want to change that hearing? You want to leave the May?
She said May 14th. I could have just talked
We're
over
set on
this.
May 14 at 1:30.
Correct.
You want to keep that for the motion to compel,
She said yes.
but you want to move out the hearing on change of venue.
Obviously.
I believe that's the only prudent thing to do at this time.
She doesn't want to is the problem. She wanted you to let them just do their
should,
shit.
Based on
Wait, why
some
is my pen
availability
dead?
of
God damn it.
team members and experts, though, I think we're not ready, or we won't have the team available until the 4th week of June for all of the people that are necessary.
You want to just wait and just talk to each other.
No, set a date.
Have a hearing again.
But I don't think we're going to have an agreement on the change of venue issue. If I thought we could come to an agreement on that, I'd say yes. Let's not.
He wants an agreement on the date.
Oh no, I'm not suggesting that you would agree on agreement on change of venue. I just mean changing the hearing.
He wants dates.
Your Honor, we would suggest the last week of June, and
just set briefing dates, Your Honor. Just look at the calendar and set the briefing dates.
if the prosecutor's ready to weigh in on that and the court's ready, we'd prefer to get a date now.
Mr. Thompson, what are your thoughts?
I think it would be appropriate to reset the dates, and really what's going to drive this in part, well, in large part, will be Your Honor's decision on what we've been talking about today. But I think it may be prudent for the court it would be prudent for the court to vacate the hearing on a motion for change of venue and prepare to reset a briefing schedule and a hearing date on the motion for change of venue to a reasonable future time.
Okay.
To allow the parties to react to whatever the court's decision may be. And I don't want the court to feel pressured on the timing of its decision. I'd rather take time
Your
to
Honor.
do it right than to rush things and just bollocks it all up.
Well, I won't rush it, and I will feel the pressure.
Appreciate that, Don.
How about we set this for 1/3? We'll vacate the hearing on change of venue and reset it for January 27. That's a Thursday, which is.
Did you just say January? Do you mean June? Please tell me if you mean June.
Seems to be a good day. They're just generally, except today. What did I say? June.
Thank God.
Your Honor,
It's a long day.
Sir, I think my Apple Watch is going to start beeping at me because you said January, because it thinks that I'm having heart issues. Like it's going to happen. June. He's talking about June 27th.
June 27. I thought you said the end of June, right?
June 27 is perfect. I am thinking, though, that we should maybe schedule for a full day. We estimated an hour for this, and we are well beyond that now, and we anticipate testimony.
Again. And it's like, you take longer than we thought, Your Honor. You take much longer than we thought.
There's 10 o'clock. Will that work?
It will. Thank you.
Thank you. Right at lunchtime. Right at noon for us.
That work for you, Mr. Thompson?
Yes, sir. We are available that day. At least those of who were right here.
Okay. And that includes Ms. Jennings?
And hoping Ms. Beatty and Mr.
Well, I'm going to ask them next, and then I'm going to go to Ms. Massa.
I'm good.
Okay, great. Okay. Mr. Nye and Ms. Beatty?
Yes, Your Honor, that date and time works for us as well.
Oh, the other
Okay,
defense
perfect.
attorneys are on
Okay, 10
Zoom.
o'clock,
Lovely.
2:27. Okay, is there anything? Oh, yeah, briefs.
Yeah, briefing schedule. Let's get the briefing schedule on the calendar.
What do you think, Ms.
Yeah.
Taylor?
I'm glad
I
you
mean,
fixed it.
I know you can't know until I give you a decision. So,
Y'all, what briefing schedule do you want? I mean, given that you're waiting on me to answer, because you don't know how long it'll take you to finish your work, depending on what I say, but like, just pick a date on the calendar. They can't do that until you
Your Honor,
rule.
the briefing schedule that the court gave us was roughly about a month prior to the hearing. We could try that, but if the court's decision takes a while, and if we're allowed to finish our surveys, then
We're gonna need more
we
time.
might have to have some time to do a supplemental.
sure. I'll be flexible about that.
You don't have much of a choice, but to be
Let's
flexible
say
about that.
hypothetically that we have more surveys, then we might even have to push it out.
That's possible.
Yeah. Especially, no. Yeah. Mr. Edelman, Dr. Edelman told me that, you don't necessarily, if you go to a larger population, that you have to have a percentage of it.
He didn't quite answer. He said he didn't quite need to.
I think the method of statistics.
Your Honor, that's not what he said. He said he doesn't need to survey a full 1% of like Boise because the representative sample size calculation isn't necessarily just 1%.
Your Honor, if we're allowed to finish what we started, we think from the time we could get it going, it would be 3 weeks. And then Dr. Edelman would need a bit of time to assimilate the data into a report.
So
You
6
think,
5
all
weeks, 4 or 5
went
weeks.
well, that you could have your briefs or whatever other information by May 31st?
Yes, yes. Your Honor, with a caveat, unless there's a long delay.
Caveat, okay?
If there's not a long delay in me knowing what we can do, yes.
She's like, look, I just.
What do you think for the state?
He's like, it's
Maybe
not a strict
deadline of
briefing schedule. She's like, that's the
June
problem.
14th?
Actually, I think that Ms. Beatty is going to be handling those venue issues. So how about we ask her?
Okay, Ms. Beatty?
And Your Honor, Mr. Nye and I will both be handling that, but that works for us.
Okay, fantastic.
Great.
And then maybe a reply by June 20? You think?
It's
can
all
do that.
theoretical.
Okay. That'll give you time to look at all that before the hearing on June 27th.
Great.
All right. Thank you for your patience.
Uh-huh.
Anything else? Then we have to talk about this one motion. You said we'll put it at the end of the case, and the end of the day.
Oh, the prosecutor's filing, yes. I'll take a look at that with him before I leave the courtroom, Your Honor.
All right. Go ahead.
If the issues that I have, if they're redacted, then we'd have a stipulation. I'll just show them what I was talking about.
Let's see if we can do that.
You two can.
Yes, sir.
All that. Okay. Anything other than Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir. Thank you.
Okay. Thank you for everybody's endurance and
Good job,
have a
Chad.
good evening. Thank you.
Well done, chat. We have survived. Miguelina, I love the end card. It looks amazing. Chat, we have survived. I'm exhausted. How about y'all? How you doing, chat? We have more court to talk about in like 12 hours. Delightful for us. Oh my goodness. I realized that with pausing, it's hard because I want to explain, but then it does take longer, and that was a long hearing anyway. I'm going to try to summarize. I'm going to answer as many questions as I can, and we will resume not this case, but others tomorrow, because we have a stream tomorrow morning. I'm exhausted. I need dinner. It's like 9:50. I didn't think it would be quite that long. Over 3 hours. The court hearing itself, let me go back to our video for that. I'm just going to quickly say, don't forget to like and subscribe. We just hit 750,000 Lawnards here, which is super exciting, and I appreciate all of it. But I'm going to go to the hearing without me pausing and just see how long it was in its natural form. 2 hours and 45 minutes. So with the pausing and the talking, a bit longer, but well, not that much longer. This is why I talk over the cases and trials. Oh my goodness. All right, let's try to do a quick summary. Emily, good luck. So, over 2 hours and 40 minutes of the quick hearing that was scheduled for 4 p.m. PST in Idaho, wherein the expert did finally testify, then had a extensive colloquy with Judge, who had some things he wanted to say and was curious about. It was a very fiery hearing. The expert is clearly offended by the prosecution insinuating that the jury pool had been tainted by the questions, was clearly offended that the media picked up and ran with the fact that the defense is in hot water, or that this was an improper survey, or that the questions were questionable, or whatever. The expert and the judge and the prosecution and the defense were all a bit feisty with one another. The point of the hearing was to determine if questions in the survey violated the non-dissemination order. And the judge decided nothing at all, and is going to be issuing a ruling later. So we don't know if the judge is determined that any of the questions violated the non-dissemination order. We have found a massive communication error between what the court considers the public record and what the defense considered the public record. The defense is trying to survey what the potential jury pool knows that is out in the public, either through media reporting, media headlines, whether that came from the court record or from wild media speculation as they, spin around in circles and talk about the case. And the expert explained, right, but if those things are out there, we need to know if they have influenced a potential jury pool in a way that makes it impossible to pick a jury here. And the prosecution has said, but does that violate the court order? And the court has said, the public record is the literal documents on the court record that has been released publicly, and some of the questions on the survey are not from or founded in that court record, even though they are in the media. And the expert explained that some of the most difficult things to overcome in the media are things that are false and highly prejudicial. And some of those questions are included in the survey. The defense seemed very frustrated. The expert seemed very frustrated. The prosecution's cross-examination was the fieriest thing I've ever seen the prosecutor Bill do in court. He was mad. I mean, the defense did use his press conference in their PowerPoint to suggest that the prosecution called for the dissemination of the probable cause affidavit, and that was the beginning of the problems. So maybe that's why he was so feisty. As he was miscommunicating with the judge at the end of the day, at one point, the judge said, well, you'll have a chance to respond. And he was like, not today, judge. Because the issue is being conflated between the surveys and the change of venue motion, because they go hand in hand. And the prosecution wants to make clear there's an answer about whether the surveys can continue and with which questions, or whether they have to stop. The defense and the defense expert want to continue their work. This goes all the way back to the beginning of the case when defense attorney Ann Taylor said, Your Honor, we're having a problem finding people who want to work with us because of the high profile nature of this case. So her concerns go all the way back to the beginning of this case when she was talking about the difficulty the defense was having in finding experts to work with them. And I understand that. So at the end of the day, lots of talking happened in court and nothing was decided yet, except that the change of venue motion will not be heard in May, and it has been kicked out to at least June 27th, depending on when and what the judge rules on and how long the briefing schedule takes. So sometime in June, we will hear a change of venue motion. And I'm not confident that there will be a ruling on it or that the judge won't turn around and say, and I said this when he decided he wanted to explore this avenue, that I'm not confident the judge isn't going to say, you know what? I think it's too early to determine a change of venue because this trial is not even set yet. I very much worry that at the end of all of this, judge is going to come back with a, you know what? We should do this closer in time to the actual trial. That is my concern here. But we will see what this judge does. He sure does like having a chat with the lawyers and talking through the process. The lawyers today, though, were less than thrilled. So they are back in court in May for another hearing on a motion to compel. We should still see the alibi filings on time. We might see the unsealing of a prosecution document that they had made a motion to unseal, but the defense has asked for some redactions. We'll see. But we already know the answer to the looming question about whether this defendant can find a jury that is unbiased in Latah County, and it is already the defense's position that that is not going to be possible. But we kind of suspected that was going to happen, didn't we? So let's get to your questions. I saw the question from Cleopatra. Was Bryan Kohberger present today? Yes, sitting between the two attorneys. Somebody had asked at the very beginning of the stream 180 million years ago, is it strategy to have him sitting between the lawyers? I think it's just so that if they need to say anything to him, they can. Oh, Mandy, I forgot to mention that the TikTok psychic case was mentioned. Ugh, darn it. Marie asked, are you covering the Chad Daybell trial starting on Monday? No, I am not. Because the Karen Reed trial out of Massachusetts is starting jury selection on Tuesday. The Daybell case, I think, is going to be the Lori Vallow case part 2. But the Karen Reed case, in a nutshell for me, is, oh, I have questions. Wait, I have questions. Wait, what? I have questions. So I am going to be very much looking at the Karen Reed case out of Massachusetts. So the chat is saying Daybell started today. Daybell, did it start opening statements today? Either way, I am not covering the Daybell case. So the Karen Reed case, I am very, very, very curious as to how that case plays out. There are a lot of questions in that case. The defendant is accused of hitting her boyfriend, who is a Massachusetts police officer, and leaving him in the cold during a huge nor'easter to die. The defense is arguing that he was attacked inside the home of other law enforcement officers who happened to be very close friends of the investigating officer, and that something else happened within the home. He was placed outside, and that is how he died. That the injuries to the victim don't match the prosecution's theory of the case, and that there is a lot there. So there are a lot of questions. There's a lot of conflicting testimony. There's a lot of conflicting information in the media about the case. I think we just need to see it play out in court. I just think we need to see it play out in court, and then we will go back and examine everything we know in the media. It's a very odd case. Oh, and the feds are investigating the prosecutor and one of the law enforcement officers. So there are a lot of questions. I am approaching it like a juror. Here's my opinion on the Karen Reed case going into it. wow, I have a lot of questions. And I want to see how those questions get answered during that trial. It's slated to be about a 5-week trial. So it is going to be an investment of time, but I have questions. Lots of them. So Kiki E said, I'm so pissed I forgot about this. Kiki E, don't worry, but hopefully you have the Law Nerd app and got your notification. That helps. So that is why, well, amongst other reasons, I'm not covering Daybell, but it's also why, as other cases have gone on over the last few weeks, I have been waiting for this trial to start because it is an investment in time. And I am very curious. I haven't seen this Karen Reed's defense attorney in trial in quite a while. He was a prosecutor in LA and did the Phil Spector case. He is a very good trial attorney. I'm very, very interested to see. Members only will be back up in a little bit. I very much wanted to make sure that people didn't get, I didn't want to, this was my worry. I didn't want to see the chat be like, oh my God, I was watching members only and I forgot we were going live on court. So I wanted to make sure that those who caught it live, and then it booted everybody back out into this so that nobody missed this, and then we can go back around. So Julia said, wait, who was an LA prosecutor? Karen Reed's defense attorney, Alan Jackson. I mean, he's also defended quite a lot of other people. So yes, he is a defense attorney now, but I'm very interested to see what happens in that case. So Tinsley, good to see you. Mother clocked in and said enough of this ish. P.S. Hey, my friend, it's good to see you. What happened today? Like, Bill kind of lost me today on the anger. There was a lot of anger from the prosecution. It seems he feels like he's being blamed. The judge was like, let's just chat. The defense is like, can we please do our job? And the expert was like, stop saying I'm tainting the jury pool. This is my job. But I also understand with the non-dissemination order that was the concern. Fat Yoga, thank you for the gifted memberships. But also, if there was not a non-dissemination order in this case, then there seems to be no avenue. The prosecution could have even raised all of this. It seems that the non-dissemination order forced the issues here. So, Stephanie in the chat said, you can't handle the taint. I also saw the comments that called Santa Taint Nick. It was just today. Anna Fox said, happy 750K on the road to I got an M, son. Yes, I'm sure G will move the bar and say something like, but the play button for 1 million subs is like not a big deal. Like the one for 10 million subs has like a diamond in it. Like I can see it happening. Lynette, Middle Tennessee replay crew catching you live. Hello. Yes, we lived for so long, the replay crew has caught up. Steph, thank you for the gifted membership. Susan, thank you for the gifted memberships. Sensationally social with Beth said, love the Law Nerd community, 750K. Congrats. Thank you. Thank you. Thank you. Rachie71 said, with my granddaughter who was born 4/1/2024. Love it. Good to see you. Thank you all for the celebratory chats. Question. Did you read my email on Karen Reed in court? If you desired a person in court, I'm close by. Thank you, Klaus, for letting me know. The team has my emails. I have not even looked at them this week, but if you sent it, we absolutely have it. We have not had a chance to circle back on stuff from this week, which will be on Friday. We must share with your boys 750K. I will. Absolutely. Bryn said, thank you, EDB, and this amazing community. Never expected to get an email during the members only, but it feels perfect. Yes, we knew. I think I said it on Tuesday. I don't remember if I said it on Tuesday. I think I said it on Tuesday that we were kind of going back to back to back on these. Should have put it in the reminders for the members only live. Forgot to do that. Was at the dentist this afternoon. So there's also that on me. Apologies. Catching Alive, and it's daylight down under. Handmaid Darcy, right? We're just, when we pick up things on Pacific time, we're just like in night court over here. Santa needs a makeover. His beard is distracting, in my opinion. I mean, will we see like a big city makeover if this case moves to Boise? I don't know. Oh, Hickers, this was the question. Is it strategic to sit him between the two lawyers? Probably so if he has a question, they can answer it for him and they're right there. So I think Ann Taylor does a fantastic job of she's incredibly mindful of humanizing her client. I know that some of you are annoyed with the sometimes the way that she pushes her case or the way that she argues in court. I thought Bill was way more kind of out of line today with his like actual just frustration. I think Ann's frustration today was like, we keep trying to say this, and Santa today was like, sir, what? So I don't think she was quite as fiery as he was, but everybody was clearly frustrated. There is not going to be anyone that can get to the end of this case and say that Ann Taylor has not zealously and vigorously represented her client. So no matter what you think of how she is doing her job, she is focused on zealously and aggressively representing her client in a way that I'm sure her client feels incredibly supported, which is her job. So she has a very high bar in a case like this, and I think she is doing that. Are there times I'm like, oh, what are we doing? Yeah, but I'm going to say that about the prosecutor too. Today was not Bill's day, sir. What are you doing? And then the thing that is starting to bug me is that he will circle it back around with like a little joke moment with the judge. And it's interesting because that is not as well received from the defense, from the judge. And I think that is frustrating to watch in real time, but it's also what she keeps trying to point out, right? You guys have a closer relationship. This is a small venue and this is what it is. So today was spicy. But I think Ann's doing her job. And again, some of the questions seemed odd to me as well. I'm like, I don't love that. So I get the prosecution's reaction of, I don't love that. But he could not say that there was anything wrong with the survey outside of the non-dissemination order. And doesn't that speak volumes? Case for your radar, Liz W. Thank you. Stephanie Haru said, finally catching alive in Japan. I know. When we work late nights, the international crew is like, hurrah, it's alive. I know. I miss that about doing occasional late night streams, but we have time. Emily, go to bed. I know. I had a whole thing today. Like I didn't think this hearing would go so long. And I had like workout and sauna plans because my hair wash schedule has gotten thrown off a little bit. So I was like, I had a whole plan and now it's like 10 o'clock. I'm like, well, fuck. My hair wash schedule is still all thrown off. Kenzie said, thank you for your excellent coverage. You're welcome. And a huge thank you for stopping by during our storm coverage. Always great to see you. Kenzie, great to see you guys too. You do amazing work. And I have nothing but the utmost of respect for everything going on the Ryan Hall Y'all channel. I love just the heart and the ethics behind the channel. Helping people stay informed so they are prepared, not scared, is a huge, huge benefit. I also love learning about the weather, especially moving from Southern California to weather where the air gets sassy and spicy and spinny. So thank you. Honey, 2800 said, I can sum this up. Here's the summary of court today because I had to go rescue Vincent. Yes, goat scream. Them joking feels more and more gross. SK, yes. Yep. I Pratt Brat said, also, I would argue that the surveyor is an agent and their questions are tainting the jury pool and injecting reasonable doubt before trial. And that's what the prosecution is arguing, right? That this is This violates the non-dissemination order because they are an agent and they are not allowed to do that. Brandon said, late night live stream, love gift. Thank you. Thanks so much. You're welcome. You're welcome. And thank you. This is a fantastic, fantastic community. I think the term should be public court record versus public media content. I think public court record would make all of this much more clear, and I agree with you. Marvelous said this is a completely unproductive hearing. More and more of the things that are happening in this courtroom, it's like, could this have been an email, and why do we need to have 3 hearings to get to the point? That's on the judge. Doesn't it make sense to just ask the jury if they're able to make a decision based on evidence provided at trial? Pratt Brat, this is a fantastic question. When I broke down the expert's affidavit and resume, he very much talks about the fact that sometimes when things are in our brain, you can say that and genuinely mean it, but you might not as a human be able to do it. And that is his area of study, that even if you say, yeah, I can be fair, can you really be fair? In a way that even if you intend to be fair, can you really be fair? And that's the point of the surveys. Mama Wolf said, I feel like at this point, no matter what is argued or shown, the venue is going to change. It might. The defense is going to make sure of it. They will make a strong stand for why Bryan Kohberger cannot get a fair trial. They will. And if that exists, it should change. If he cannot get a fair trial in that county, it should change. But it shouldn't, there has to be a bar for that because it is a tremendous burden. And the community does have a vested interest in the case. But the constitutional rights are Kohberger's and Kohberger's alone, not the victims, not the communities, not the prosecutions, not the governments. His, and the defense did a good job of circling that back around at the end, maybe not so much to remind the judge, but to remind everyone else that the rights that matter in this courtroom are the rights of the defendant. Those are the constitutional rights that they are trying to protect. So as frustrating as that is, and as overwhelming as that can be, that's just facts of how the Constitution and our court system work, or are supposed to work. Jason says, thank you for making law more accessible, Emily. Jason, thank you for seeing me. That is what I try to do. As I've said, but the surveyors don't identify as anyone pertaining to the case, correct? So it shouldn't hold the same weight as an attorney asking. That's what the defense is arguing, that this is just a neutral party saying, can we ask you some questions about this case? Just a survey. You don't know where the survey is coming from. But the language of the non-dissemination order holds the parties and their agents at weight. And now everyone who's paying attention to this case knows where the survey is coming from because it's all been publicly discussed in court. So now it's out there. Abby said, Ryan Hall, y'all, and EDB, 2 of my favorite sides of YouTube. I never thought I'd see collide. Thank you both for all the wonderful work you do. I love watching other streamers. I love watching how other streamers do their work. I love his whole Stream Center setup. I love JB's Stream Center setup. I love people who are like, you know what? I can bring this information. I can try to help. I can try to bring facts. I can try to make things make sense. I can try to demystify it. I love that. And I love watching it. And there's so many lawyers here that are doing that too. I love it. I think there's a lot of value there. So I love it. I love supporting it all that I can. Cross Stitch said, shouldn't the survey questions be put together by defense prosecution in court? Nobody asked that question. So I don't know. That's what they do when they do the veneer surveys. But the defense kind of said, this is how this is done. Shane said, what? Shane, you know my kid watches this. Shane said, was that a double taint? Yes. I think a double tap and a double taint. It was all the things, Shane. Rob said, and I think Rob has already bounced. Rob said, here's the thing. If we're going to determine whether a jury pool is tainted by the media or double tainted by the media, they need to be exempted from non-dissemination order, or defense prosecution can't fully argue the issue. Right? Or they have to argue it in a closed hearing. I mean, they've done that plenty too. Roro, thank you for the gifted memberships. Christine said, how can they disseminate something that was never there to begin with? It's also a valid question, but the things that are being disseminated or questioned are things that the media was saying. Diane Sanchez said, but people are calling the police in the DA's office. They aren't calling the defense, so the quote unquote people must feel the defense is doing something quote unquote foul. Diane, I absolutely hear you. I think the argument on the other side would be to that, and that's just to elucidate the issue and not to argue with you, is I think the defense would say, see, this community is so close-knit and they already are predisposed against Kohberger. That's why they are calling the prosecution over a survey. I think that the prosecution is probably more accessible and people are like, oh, this survey seems weird. Somebody's asking me about the case. Like, it wouldn't occur to me to call the defense attorney either and be like, somebody's asking about the case. So I can see it, but I think there's the defense might see it differently. So I try to point out where the defense might see it differently. Smurfana said, he just said because they knew the info, they're already biased. No, just because I know something doesn't mean I can't have an open mind. And I think that's fair too. And that's what the argument in court's going to be. That's why they're setting aside for a whole day. So Diane is asking, so Ann Taylor wants a change of venue. The expert is saying in general, he won't get a fair trial anywhere in Idaho because of the prosecutor. No, I think he was saying that the information was being disseminated by the prosecutor. So the survey was not tainting the jury pool. The prosecutor put that out there. Bill was big mad for sure. Ann said, Judge must have a boring ass docket. He looks forward to these meetings. I think so. I don't think Judge is as busy as he needs to be. I think he needs more stimulus in his workday. Paula said, but if I say in the survey that I'd heard about the case, then he'd go on and tell me that BK stalked his victims and now I'm prejudiced, for fuck's sake. Paula, and that's the prosecution's argument. Absolutely. Evil Oddish said, thanks for covering him off to bed. It's 3 a.m. 3 a.m. and they called me and I'm still awake. I'm going to forget the rest of that, but like the scene from Grey's Anatomy is seared in my brain. Sandy, thank you for the gifted memberships. Brendan, thank you for the gifted memberships. Daydream 1013 said, small note, but I love the fact that the judge has a ThinkPad laptop because I work in IT and that's laptops I work with. Hold up, Judge looking at his phone. Is he in the chat? What the fuck? I wonder if he was door dashing food to Chambers. Like, Rob, I'm tired. There are so many questions. And I haven't fully processed yet because it was very late in the day and we've had a lot going on today, but a lot has happened in the last few days, but not today, Your Honor. And the fact that the TikTok psychic came up are things that were not on my docket, but it is late. This is the time I would normally be wrapping up a members only live stream though, and then rolling into finishing prepping for tomorrow. So don't worry. Y'all don't forget to take a Tums before bed to help with all the spiciness. I know I need to go eat dinner. That's what I need to do. Lovely said, let them change venue. The evidence should be enough to convict him. I mean, the evidence will be what it will be. I think the prosecution is fighting for the community in this, saying we're not just going somewhere else. Like, this community has a vested interest. And Taylor is arguing that that's exactly the problem. So they're not going to see it the same way. Lindsay said Ian may not have a stats degree, but here is another Canadian friend of the channel who simply does. That's true. And who even worked in crime statistics for a fair amount of time. I would love to know Simply's thoughts on all of this. There was so much statistical analysis. There's lots of crime stats happening. And that is true. Very true. Steven said, I'm curious to see how the legal system evolves in the era of viral content. Will we see more sealed filings from beginning and up to trial, less public access, FOIA changes? I don't know, but it is something I'm also very interested in and something I'm going to keep my kind of eye towards, because there is a push-pull between transparency in our courts, which I think is a very good thing, and then the other side of that coin can be very difficult. Parties not being able to find experts being one of them. And if you were an expert that did these things and watched Depp Heard, would you, if you were asked to be an expert for a high profile case, say yes? Like, would you? What about in a case like this? If you are a preeminent defense expert in something, or just a neutral expert and whatever, would you want to be in a case that is this high profile? And does the high profile nature of a case start skewing access to justice for victims or defendants? Does it already impede the case from the beginning? Or does it help the case because more attention means more answers, means more info? I don't know. But I think it is absolutely something that we have to keep in mind. And I think the standards of evidence when we look at cell phone data, et cetera, also needs to continue to evolve when we look at how is evidence authenticated, what evidence being authenticated in a digital age looks like, and how to continue doing it, and how to keep out evidence that can't be authenticated. Because again, I covered this ages ago, like 3 years ago, maybe. The cheerleader mom that got arrested and convicted and ended up going to custody. I don't remember if it was jail or prison, but she deep faked a video of another teen on the cheerleading team. And then after deep faking the video, disseminated it to the coaches. And after disseminating it to the coaches, then used that video as evidence that this child should be kicked off of the cheerleading team to elevate her child's position on the cheerleading team. But that was someone who was not tremendously tech savvy. This was 3-4 years ago. And someone who was able to use apps on their phone to deepfake a video convincing enough that the higher ups on the cheer team were like, yeah, this is a problem. If it were not for the mother of the targeted cheerleader saying, I believe you, honey, I don't think this is you in these videos. What the fuck is happening here? And then the police department also taking it seriously, which I could see in a larger jurisdiction like Los Angeles, the police department being like, I'm sorry, you're here because you're saying there's a deep faked video of your child who's a cheerleader and they got kicked off the cheer team. What would you like us to do about that? The police department also took it seriously and pursued where that video came from, ran it down digitally, which takes a tremendous amount of time, energy, and resources, ran it down digitally and actually prosecuted somebody. But the likelihood of the prosecution happening is not high enough really to deter people from doing that. I appreciate that YouTube is starting to ask the question to mark content as to whether or not the content is altered. I don't know what systems double check that yet, like what the checks and balances on it are, because there is content that's not authentic or real that's digitally created that can be fascinating. But there is content that is not real, that is digitally faked, that can be hugely detrimental. So we live in a time where we're going to have to figure out how to navigate that, and how to navigate that in a time where when people are like, no, that's not me, I think there's a level of like believe but question, because I can see bad actors being like, everything's faked, right? But you can also see people who are authentically targeted that are like, no, it's not me. And how do you unring that bell? We are living in interesting times. We are going to have to learn how to navigate it as not just a court system, but as a society. And it's hard. But I think the thing that we need the most, I know, are to keep asking the questions and having the conversation. And if we keep asking the questions and having the conversations, we can start to identify the problems that need to at least be discussed. But if we don't ask the questions and we don't have the conversations, then I don't think we get to the best answers. And that is a thing. So I'm going to answer just a few more because I have a few more. But Stephen, I think it's a very interesting question. I hope that as the law nerds, we can keep having the conversations as we look at navigating this in court. Shell said at this point, I'm annoyed with all sides. It's fair. All of them should have been able to either settle this, file everything under seal, or none of this would have been public. I don't know how it got here. The prosecution filed it under seal, and then the defense didn't, and then the wheels came off. But I'm sure the defense had reasons. The defense was really mad that the prosecution filed a motion and the judge made an order the same day. I understand why they were mad. Her Royal Abbiness said, as law nerds, we have questions. I followed EDB's coverage of this case, and I still think I could be convinced I could be fair because I have questions. The state believes their case, but innocent people have been convicted before. Right. I think coming into most cases with a sense of curiosity is where we all strive for. I always strive, and I can't do it in every case, and I let you know where I can't do it. There are some cases that are harder for me than others, and we have those conversations, and I normally don't follow them at trial. Like, I lose objectivity somewhere as the evidence came in the Ruby Frankie case. I'm like, I am trying to keep an open mind here, but I'm struggling because this case is horrifying. So with them pleading, I was like, good. But with most cases, my approach is, I have questions. I'm curious. I want you to tell me why. Tell me why this happened. Tell me how this happened. Tell me things and back those things up with facts. Tell me what happened or didn't happen. Tell me why. And I always vote for good court. I want to see good lawyers doing good lawyering with good judges making rulings, because there will always be spicy moments in court, but good lawyering is fantastic to see. You know, there are times when it is amusing to watch, 10-year-olds play sports. There are times it is better to watch professional sports. I would like the court cases that we watch to lean to the professional sports, not, 10-year-olds playing sports. Sometimes there's time for it. I'm always rooting for good lawyering, good court, and answer my questions. That's it. Chad, I see you telling me to go to bed. I'm getting ready to. SK said he can't complete his analysis because he can't compare. Thank you for tying that point back around. Lorraine said no case would ever be tried if we go with his logic. Just because someone heard something doesn't mean a person can't wait for evidence. Agreed, they are trying to figure out how true that is. Her Royal Abbiness said, not a statistician, but I have taken 3 separate statistics courses and have participated in developing standardized tests and their interpretation. This expert knows his stuff, and I'm having statistics class flashbacks. He definitely is an experty expert. Aaron Evans said, to those saying expert bias, he mentioned doing a survey for one of the George Floyd murders. I live in Minneapolis. The venue didn't change despite much trying. If there's no need, he'll say so. And he has said that repeatedly. If there is no need, he will say so. And it looks like in cases he has said there is no need. Laura said, couldn't this just be jogging an OG memory or a suggestion of a desired answer? I think he tried to get into how that happens and how you solve for that, but some of that was lost behind a PowerPoint for me. Danielle, thank you for the super chat. EDB sociologists, such as myself, are here to study groups of people as opposed to psych, which is the study of one individual, also including stats and surveys. Why didn't they have a sociologist on the stand instead of, or along with a PhD? It's my understanding, Danielle, that his PhD is in social psychology. That was what I remember from his resume and his filings. But the defense gets to choose who their experts are. So why they pick one over the other, I do not know. That is their choice. I've never had to make that choice. So with all of that chat, I'm exhausted. I will see you soon. I appreciate you. I will see you sooner than I thought I would. So I might set the stream a little later tomorrow. Download the Lawnerd app. I might set the stream a touch later for tomorrow, just to give everybody a little bit of time, to give the mods time and to give myself a little time, because it is almost 10:30 where I am, so it's going to be late. Thank you guys for being here. Get the Lawnerd app. I will see you on stream tomorrow. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Lawnerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Lawnerd.